So we want to continue what we started discussing the last time. We discussed about judgment and decisions, but we haven't discussed execution or enforcement of judgment, and that is what we want to discuss in the first session today. And then when we finish with that, we move on to some other areas. Hopefully, we should exhaust most of the outstanding topics today. So one important point we made with respect to judgment from our last class was that judgment refers to a decision of the court or the ruling of the court. So if you look at the interpretation section, so order of the court, decision of the court, ruling of the court, they're all included in what we call judgments. But we did emphasize that if a judgment is made and you want to take any step on it, you must first and foremost draw up entry of what? Judgment. So the entry of judgment is authoritative summary, the substance of the judgment, and for that matter, the orders which the court has made. And that will have to be drawn up. You take it to the registrar of the court, for the registrar of the court to pass it, to look at it that yes, what you have drawn up is consistent with the judgment that the court gave. So I'll put my stamp on it, and then it's recognized as a formal entry of what? Judgment. And then it will have to be served on the other party. If it's not served on the other party, you cannot take steps to enforce it. So that is very important. And if you look at the rules, there's a certain duration which is prescribed. How long should it be served before you can do any other thing in the rules? We look at the rules, entry of judgment, when it's served, a certain period will have to elapse before you can do anything. Yes, look at your law and tell me. I want answer from the law, not from your head. Look at your law and tell me, raise up your hand if you are ready. We haven't looked at the law ever since we closed that class. I think we had that class online, not in classroom like this. Yes. So entry of judgment, which rule relates to entry of judgment? Yes. Which rule relates to entry of judgment? 41 rewards. Read it for us. So somebody is saying 41 with 4, another is saying 41 with 7. So all of you read. So the first person, order 41, 7, read that for us, and then take the other one. Yes, you have your law before you. 8. Yes. The 41 with 7. What does it say? The party seeking to have a judgment and shall draw up the judgment, present it to the registrar for what? Entry. That is what we just said. And then 41, 7, 2. Where judgment is presented for entry in accordance with this rule, the registrar shall enter it in the book kept for that purpose, file the judgment, and return a duplicate of it to the party who presented for entry. Now, there used to be a problem where people would actually, and we need to tell you this. You see, society is made up of good and bad people. And of course, all human beings we are prone to do what is bad unless we restrain ourselves. So when it comes to law and the law practice, the same thing applies. There are times people can even make up story that a court has given a judgment, when in fact there may be no judgment, isn't it? Good. So in the past, a practice developed that we have people like you have a judgment record book. Apart from the judge's record, the judgment is served and the intro judgment, you have to paste it in the book. The one printer, you have to actually paste it in the book so that for future purposes, because judges don't live forever. And once you give a judgment, you become, what is the legal term? Punctual sort issue. Good. But it's record of the courts and it's for the state. So at every point in time, we should be able to establish what the true position is. I'm getting a feedback. Is it okay, class prefect? Is it from your mic? Or because somebody's mic is on? You put your mic off and let's, is it off? Okay. Yeah, so 41.7.4. The order referred to in subgroup 3 shall, when drawn up, be produced at the registry together with a copy of it, and when passed by the registrar, the order shall be sealed and returned to the party who produce it, and then a copy shall be lodged in the registry. Now, the 7 days, why do we get the 7 days? No, sorry. There's a period. Mandatory, yes, where do we get it from? Sub-rule, read it for us.
Shall not authorize party in this favor the authority, and the council fails to draft the order of this 7 days after decision. Any other party affected, the order may draw it out.
I mean, that is fine, but there's still another 7 days. This one is talking about, let's say that a judgment is made, usually the plaintiff, you took the matter to court. So one would expect that if a judgment is entered, if it's against you, like if a judgment went against you as the plaintiff, you have the two parts. Usually because the plaintiff lost, he may not have the motivation to do the entry of judgment because it doesn't stand to benefit from it, isn't it? But here is a case with the defendant, you won against the plaintiff. So you can also act. You can also act and have the judgment drawn up. Or sometimes maybe if about the property, some recovery of possession or some other things are made, and you are affected by it. Once you are aware, you can also take steps to have it drawn up as it were. Yes.
I got to put in the time frame that is because of the plaintiff that is the issue also. It's the plaintiff that is supposed to draw the.
Like in theory, that will be the ideal. But usually in practice, if you lose, a judgment is centered against you, you don't have any benefit to get from the judgment. You don't have motivation to do anything after it, isn't it?
There's a good case, or it can be any time with the after that in terms of a judgment when in favor of them against the defendant, all right. And then the defendant, because they want to appeal the case, would go ahead of the plaintiff to
draw the entry of judgment.
So I was asking, so can the two do it together, or there's a time frame within which the plaintiff is given to that the plaintiff doesn't do that, then the defendants are now.
Also,
Two of them will end up doing the same.
good. So if you look at the 41-7-3, as we read, that as a general rule, when order is made, you're supposed to have the entry made within what? 7 days. So if after the 7 days, it is not done, then anybody who has got an interest in the particular order can take the step to have it drawn up and take it to the registry for the registrar to review it if it is properly what, reflecting what the judge said or ordered.
My Lord, for the 7 days, this is called a date.
The party, yes, ordinary. If it's a plaintiff in whose favor the order was made. But it's not all the time that the plaintiff may be the losing part. So if the defendant, you are the party who won, isn't it? Yes. Good. And then we also have entry as to cost when we discovered the 74. Sometimes, because judgments also includes order. So if an order has made that the cost should be recovered or should be awarded against someone, if you want to enforce the cost, you also need to do entry of what? Of cost. Just the same way an entry of judgment is run, you draw it up and then go and serve the other part. After 7 days of serving it, if it's not taking steps to pay, you can now invoke any of the things we are going to discuss now. There's a question of what? Judgment, there's a question as to cost, as it were. But we come back to this again. So we want to look at execution of the judgment, and from the syllabus, we are supposed to understand the purpose and then the legal principles which govern execution of judgment. And again, we should develop the ability to identify and select the appropriate modes of execution. There are various types of modes. So which of the modes are you going to use? And we should also appreciate the role of the court in supervising execution. Execution is something which is done under the supervision or control of the court. But mind you, execution is also an aspect of deployment of the sovereignty of the state, especially the coercive element of state sovereignty. So first and foremost, when we say execution, what is it? Execution or enforcement of judgment. So execution is a process by which a judgment creditor realizes the fruits of a judgment through the coercive power of the courts. The court has made judgment, but the judgment cannot enforce itself. Certain processes, certain mechanisms will have to be deployed or activated for the judgment so rendered to bite. To bite means that to have effect, isn't it? Yes, so all the things which will be done to let the judgment have effect is what we call execution. So it is a final stage of civil litigation, and it translates judicial pronouncement into practical satisfaction. If the judge has made pronouncement, yes, you are right, the defendant is wrong, you're entitled to this and so on, it's only a pronouncement. How do you have the benefit of that? You have the benefit of that pronouncement through execution. So if you're a successful litigant, in a sense, you don't get any benefits from the judgment unless and until it is enforced. And that is why execution is very important. So if you look at the rules, the order 40, of course, starting from order 41, order 43, 44, 45, 47, and even 50. On Committal, that is the, what do you call the contempt of courts, and over to some extent, even the 49. They are all important rules you must be very familiar with as far as execution is concerned. So let us keep that in mind. So first and foremost, the execution that we do depends upon the type of judgment which you have. So let's keep that in mind. The type of judgment which you have will determine the type of execution to activate. So if you go to under 43, rule 1, for example, you notice that it does not use the word execution. It uses the word what? Enforcement. So meaning that they are all the same. So other enforcement of judgment or execution of judgment, we are talking about the same thing. And if you look at under 43 rule 1, it's giving the various modes or the various mechanisms available for execution or enforcement of judgments. And the mode to be deployed will depend upon the type of judgment. So if you have a money judgment, that is judgment for payment of money, you are going to use what we call the rate of fi.fa. Although it's written rate of fieri facias, but I don't say rate of fieri facias. We simply say rate of fi.fa. Fi.fa, all of us. Yes. If I hear anybody say rate of fieri facias, I'll be very sad. Yes. So just fi.fa. That is. If you can't say fi.fa, you say rate of FIFA, at least you are close. We take that. And then so we come and discuss them one by one. But if the judgment is about payment of money, you ordinarily think of fi.fa, rate of fi.fa, or Garnishee. No, Garnishee proceeding, we come and talk about that. That's where you are saying that the judgment debtor has got money with the third party, and the money in the third party belongs to the judgment debtor. So the judgment debtor is supposed to pay me. The third party, that is Garnishee, in possession of the money, should be made to come and prove to the court why the money should not be given to me to satisfy the judgment I have against the judgment debtor. So if it's judgment for payment of money, these two are the most common sought after, fi.fa and then Garnishee. But of course, the Garnishee will depend upon whether the judgment debtor has got money with a third party. If it does not have money with a third party, that is not relevant, isn't it? But then the fi.fa is where you look for a property belonging to the judgment debtor, and then you have it auctioned, you have it sold by judicial sale, so that you get the money to pay whatever debt there is. But we come and discuss that in detail. Again, if the type of judgment you have is about maybe for possession of land, yes, the court made declaration of title and then ordered the possession in your favor. Then the mode of execution you need is a rate of what? Possession, as it were, a rate of possession. Again, if it's about goods, maybe goods are supposed to be given up to you, delivery of charter, the rate of delivery. Maybe someone has detained your goods, or someone is exercising the right of lien, for example. He is exercising the right of lien, and for that matter, he doesn't want to release the goods to you. You sued, and then the person asserted the defense of the right of what? Of lien. But then the court goes into the merits and court saying that, well, that was not well-funded. So you're not supposed to have actually held on, or I mean, you're not supposed to have held on to the property of the person. So the rate of lien, I mean, when you exercise was not called for. So give the person's property back to the person. So if it is if it's movable, not immovable, of course, immovable will always be land. I will always be rate of possession. But if it is movable, that is something which is not fixed to the land, then the rate of what delivery will be appropriate. And then sometimes we have how to call the rate of sequestration. Rate of sequestration. So rate of sequestration, maybe for example, someone has defied the orders of the court, contempt of court, and then the court has ordered that certain things in his possession should forcibly be taken over. Then you have to be sequestrated, as it were. Or sometimes the court may even have to say that a certain encumbrance, a certain charge should be placed on somebody's property as part of enforcing a judgment. So let's give you an example. Let's suppose that maybe either depending upon the particular configuration of facts, the court may order a charging order or even a receiver, somebody to be appointed to collecting money. That is also a form of enforcing judgment. You remember the law, or the debentures when it comes to company law, floating charge and fixed charge, isn't it? So sometimes you may need somebody to be appointed to collecting money from income stream. So that is also a form of realizing a certain order which has been made. Or even an injunction is made. You need to enforce that. How do you enforce that? By contempt of court. The court made an order of injunction that somebody should not step on a certain land, or someone should not do certain things. And then the person is doing the very thing the court said should not be done. So if you can prove it, that the person has actually defied the courts, then you want the person to be punished for disobeying the orders of the court. The person will have to be committed, will have to be cited for contempt of court. So let's read order 43.1 before we continue. 43.1 and 2 before we continue. 43.1, stop with 1 and 2, that's what I mean. Subject to these rules, a judgment or order for the payment of money, not being a judgment or order for payment of money into courts, may be enforced by one or more of the following: rate of fi.fa, Garnishee proceedings, charging order, appointment of a receiver. In a case which Rule 5 applies, an order of committal or rate of sequestration. And then 2, subject to these rules, a judgment or order for payment of money into court may be enforced by one or more of the following means: appointment of a receiver, in the case in which Rule 5 applies, an order of committal or rate of sequestration. So you are being told where you have money for enforcement of what? Payment of money. Then these are the options available to you. But as I said, some of them will depend upon the actual facts on the ground. If the judgment debtor is the one against whom the court has ordered that money should be paid, he should pay the money to someone, so the judgment debtor, the losing party. So if the judgment debtor or the losing party does not have money with any third party, you can't think of what? Garnishee, isn't it? So we have to look for other person's property. Now, with respect to contempt, in the district court, for example, they used what we call the summons to show cause. The district court, before we came to have this CI 59, under the old rules, there was something we call the summons to show cause. So over there, instead of the entry of judgment, they call the formal decree the same thing. So when the formal decree is served on you, then the next thing they will do is for someone to show cause to be served on you. In other words, come and show cause. Why the court should not send you to prison for you failing to pay your judgment debts? Of course, that was abused a lot. And a lot of the citizens operate at the district court. I will try, if you finish early, I'll try and have a one-day lecture where we will discuss the district court rules. Just in a session. Because when you become lawyers, most of you, that's what you'll be operating. before you come to the circuit court and then the high court, except that most of the principles that we are discussing are applicable mutatis mutandis to the district court, but they also have their own rules, CI 59. So, of course, the Supreme Court said that it's against fundamental human rights for somebody to be committed to prison for non-payment of what? Yes. So, it's not the case that you cannot be committed to prison, but that will not be the primary means. Previously, it was like the primary mode of execution for a lot of this payment of money, especially in the district court. And the court said that no, it's against human rights. But it is different where maybe certain other things are done and you either disregarded the court order and then you are in prison for contempt of court. That one is different from the previous situation where you be there. They serve you processes that the court said you are supposed to pay me 10,000. I will serve you this notice. Come to court on Monday. You come and explain to the court why you should not be sent to prison for you not having paid the 10,000. That used to be the practice. And that is not right, isn't it? After all, they say, oh, come forward. Come forward, yes. So, then, yes. Yes.
So, just exactly, I witnessed a case where the lady, where someone.
We have our colleagues online, so you have to speak loud so that all of us can hear what you are saying. Yes.
There was a situation where someone had defaulted.
Okay.
At the high court, and then the person was given a court. I think it was 10,000. But the person didn't pay, and the person had come to file another case in a different high court. But where I got confused was when during the first examination, she was asked why she hadn't paid the cost for where she had the judgment against her. She said she didn't pay because the judgment was baseless. So, in fact, I was surprised. So I was like, wouldn't she be in contempt? But it looked like it was normal for the court, and I was the only alien in court. So if you could please explain that.
Oh, she actually, well, we don't have the benefit of what we had, but I think that a court of law ordinarily would not preside over insolent or scandalous behavior. When you talk about contempt of court, it's not about the person of the judge. And I always made the point that the dignity we give to the judge is not for their person, but for the position that they hold. So, if the person spoke that way, any court would definitely call the witness to. Any court would definitely call the witness to an order, because you cannot use insulting and scandalous language in the court, isn't it? And you will notice that, especially when we are learning about contempt of courts, it is the position of the law that even the most quote-unquote, I've said, quote-unquote, I've said bad, bogus judgment or ruling must be obeyed unless and until it is set aside or stayed. A so-called bogus, I've said, to your mind, even quote-unquote silly judgment or orders, is binding in law unless and until it is either set aside, like on appeal or stayed or quashed on judicial review. And that's the judgment of the court. So you cannot pick and choose and say that, well, this judgment, I didn't obey it because to my mind, this is quite, it's a bullshit, it's bogus. You can't do that. You understand? You can't do that. You cannot pick and choose, or you cannot decide whether the judgment is good or bad before you obey it. Once the judgment of court and it's not being reversed, even sometimes even be wrong. I mean, based upon you can say, oh no, this is wrong, but not until you've done the necessary things to have a set aside. That's the judgment of what? The court. And that is why if you are being held in contempt, or you are cited for contempt of court, it's not defense for you to say that I didn't obey the orders of the court because it was bad. I think it's a wrong judgment. And I've asked my lawyers to appeal against it. No. If you have filed appeal does not operate as a stay. You must get a stay of execution before you be freed from obeying the judgment. If campus is low in there, the battery is low. Okay. 10 minutes. You need to charge it. Okay. Yeah, so if a judgment is wrong, until it is reversed on appeal, it's binding on you, or it is quashed in judicial review, or it is stayed, it is binding on you. So let's keep that in mind. Yeah, and that is why I find that a bit strange. Yeah, if it actually did happen, yes. Okay, so we'll come back and discuss the specifics, but another general thing we should keep in mind is that before execution or enforcement, we have a condition precedent which must be always fulfilled. One, judgment must be drawn up and entered. And we discussed that in our previous class. So the judgment you are seeking to execute must be drawn up and what? And entered. So that is very important. So look at the 41 rule 7, we discussed that already. And we noted that ordinary is a part in whose favor the judgment is made, who is supposed to have it drawn up within 7 days of it being made. And let me say that not until entry of judgment is done, you cannot implement it. And sometimes in practice, a judgment is made. You send a letter to the court for the judgment delivered. And maybe there's a delay. So what do? The judgment is for you. That is why on the day the judgment is being given, you have to make sure that the actual orders, you record them. So that if you haven't had the full judgment of that, but because you heard it, you took notes, you can use it to do your entry of what? Of judgment. And enable you to start the execution process. Otherwise, you are going to lose. Later on, when the signed judgment is made available and you think that there's some slight discrepancy, you can always file motion for amendment of that and get it sorted out. The second condition precedent is that time for compliance, if any, must expire. So before execution, if the judge gave a time for certain things to be done, then not until the time given has actually expired or elapsed, you cannot engage the mechanism for enforcement or execution of judgment. So let's keep that in mind. Then 3, before execution, necessary leave must be obtained where required. There are some situations in which you may need to go for leave, and you need to actually go for that before you can do the particular execution. So let's keep these general things in mind. Another point to note is also that execution, as we have stated, is under the supervision of the court, meaning that execution is controlled by the court. It is also subject to judicial discretion. And that is why execution may be stayed or set aside. As well, when it comes to payment of money, the judgment debtor may bring an application for instrumental payment. And then the judge may agree and say that yes, your request for payment in installment has been granted. So execution is stayed, meaning that the judgment creditor cannot go ahead and use the modes or mechanisms of execution because the court has accepted the payment for, instrumental or payment, as it were. So let's keep that in mind. Now let's take a rate of fi.fa and look at it. Yes.
So that the payments, the installment are short finishes. And must the judgment creditor give consent?
Okay, good. Good. So in terms of consent, it's a discretion. The court will look at what both of you are saying. But whether to be granted or not does not depend only on the wishes of the judgment creditor. Except that if you disagree with the court order granting instrumental, you can also appeal what? Against it. You can appeal against it, but it doesn't mean that you must necessarily consent before the court can give an order for you to, for the judgment debtor to pay in what installment. And with respect to the interest, the law is that the judgment attracts interest from the day the judgment is entered. There's a CI 52. I would like, I'm sure you have it already. You don't have, just download it. The formula for computation of interest on judgment, CI 52. So just download it. And so two things, if, for example, if it's a contract, and then the contract is quite elaborate on, let's say, interest payment, let's suppose that we have a liquidated damage clause. And the liquidated damage clause has been prescribed the formula for interest. Then, if it goes up to the time that the last payment is to be made, that may well be so. Otherwise, we have a default rule, which is the previously we used to have like the prevailing commercial interest rate, but these days we don't have a standard rate. The bankers here will tell you. Of course, the BOG will give what they call what do they call it? Is it the prime or what do they call it? The prime, yes. And then it's up to the various banks to work around it, either plus or 1 or plus 2 or whatever, yeah. But then the average, if you like, that will suffice. Yes.
So where the court has granted payment to installment, for example, the first installment is prepaid in the first 3 months.
Yes.
And the judgment debtor defaults in paying
the first tranche of the installment.
Can
yes.
You go for enforcement on that one, or you have to wait until the whole period elapses or can go for enforcement.
Okay, thank you. So it will depend very much on how the order for installment was made. So sometimes it will be that where there is a default, automatically all the rest become immediately due and payable. Yes. Because installment payment, ordinarily, if you miss it, unless before the time is due, you've actually gone to court for extension of time or something like that for the court to make a variation. Otherwise, especially the starting installments, if in the middle of it things become difficult and you're able to go to court timeously before the time is due for that particular tranche be paid, probably if a good case is set up, some variation may be made in your favor. But the bottom line is bona fides or good faith. You must always show good faith, isn't it? Because every judgment creditor would like to get this or her money. So why are you standing my way? So if you want us to make things flexible, you must also cooperate with the process. Go. So fi.fa, let's discuss that a little bit more before we move on to the others. And So what is fi.fa? As I said, it's written fieri facias, but we don't say it like that. We just pronounce it fi.fa, fi.fa, as it were. And it is a judicial writ issued by the courts, directing the bailiff or the bailiff or the sheriff to levy execution on the on the property of the judgment debtor. So that is seize the property, that is take it by force and sell it to satisfy the judgment debt. So that is basically what the fi.fa is about. Authorization given to the sheriff. The sheriff is supposed to be like, if you like, the law enforcement person, as it were, attached to the court or the bailiff to levy execution on the property of a judgment debtor. And what that means is that he's supposed to seize it, that is, take it compulsorily, sell it, and use the proceeds to satisfy the judgment debt. Now, maybe the historical origin of this mode of execution. The fi.fa comes from a Latin, which literally means that you cause to be made. That you cause to be made. That's the literal meaning from the Latin rendition. So the writ commands the sheriff to cause the money adjudged to be paid to be realized from the debtor's property. So the judgment debtor is supposed to pay money. He has property. So give the writ to the officer of the court, the sheriff or the bailiff, that he should cause the money which the court has adjudged to be paid by the judgment debtor to be realized, to be raised from the sale of the judgment debtor's property. So as you notice, it is coercive execution process. There's element of force in it. There's element of force. That is why sometimes you may be driving your car and then the police will say that, stop, get down from the car, bring the key, see the order of the court. You're taking over taking it to the court or to any designated place. Somebody authorized as auctioneer to do this as it were. Because there's an element of force, so there's a coercive execution process. And again, fi.fa is a remedy against property, not the person. So let's know that. It's a remedy against the property, not the person. Yes.
This what happens if the property, as of the time that the writ of fi.fa is issued, is occupying for what people are in the property and ready to do out of the period that the writ was issued. That was the first time.
So let's suppose that you are going to sell let's say a house.
Yes.
You are going to, and the people are there. Yes, there'll be served notice. Just as if you are going to have a writ of possession, because this one is you have to actually, sometimes the two will have to go together. So you have to go the writ in need of writ. You are going to do writ of let's say fi.fa, but what the person has is a house, and then the house too, people are occupying it, isn't it? So it may even be necessary for you to get you also go and say that the rate of execution possession, so that you eject everybody from it. And then you have a vacant property. So that if you say you are selling it, nobody wants litigation. So if I want to buy a house, I don't want to be, later on be litigating, even if I'm going to win, to waste my time and energy, to be contending with people who are already in possession, isn't it? So maybe it may be necessary for the person seeing to the execution to get, let's say that the rate of possession, as it were, to get everybody out before even the sale will also go on, as it were. And of course, because people are in, they're also entitled to be heard, isn't it? If you are discussing possession, if you remember, we said that if somebody is in possession and you are going to execute the writ of possession, before the court can grant it, they should have been put on notice so that if they have anything to say, they can come to court and tell the court before the court will go ahead and decide whether to grant it or not to grant it, as it were. So we have to look at the order 45. The 45. And it's not really plenty, so there's about 15 rules. There's under 15 rules and under 45, isn't it? Why? It's not plenty, is it plenty? No, I mean, some of them are just, it's not plenty, isn't it? So let's look at the law and then we'll discuss. So the 45, rule 1, a judgment for payment of money may be enforced by a writ of fi.fa. So where a writ of fi.fa is issued, it shall be executed by the seizure and sale of the debtor's property sufficient to satisfy the amount of the judgment debt, together with post-judgment interest at the appropriate rates until payment and the cost of the execution. Now, writ of fi.fa should not be new to you. Those of you who are familiar with the Christian Bible, one of the parables of Jesus, somebody was owing, isn't it? And then the person was actually forgiving, and he decided to go after other people. And then later on, they went to tell the master that this person you were good to, look what he was only going to do to who are owing him. Then the master got angry. And they said, okay, because he's owing him, he's had him actually, if for him, he deployed a number of execution. Both, not only his property, I think his person was also, someone to show cause was also a deployment against him, if you remember the story. So this is not anything new. So the money which will be realized from the forcible sale of the seed property, we use to pay the judgment debts. And not only that, somebody has a question, does interest accrue after judgment? Yes. So the interest accruing from the date of the judgment up to the time of the fi.fa, all will be taken from the money realized from the sale of the property. And also cost. The cost awarded will also be. And interest also accrue on the cost. Because if you are supposed to pay today, you haven't paid. Interest is accruing, isn't it? It becomes the form of like a debt. Let's look at the 45(2). A party entitled to enforce a judgment or order by writ of fi.fa may issue 2 or more such writs directed to different registrars at the same time or different times to enforce that judgment or order, but no more shall be levied under all those writs together than is authorized to be levied under one of them. So what order 45 rule 2 is telling us is that it is permissible to have more than one writ of fi.fa. And what does that mean? That is to say that the court has adjudged that you should pay me 1 million Ghana cedis. And I noticed that you have, let's say that something in Kumasi, you have another thing in Ho, another thing in, let's say, Takoradi, and something in Accra. If I do the rough valuation, your thing at Kumasi cannot actually come up with 1 million, isn't it? Maybe it's worth 200,000. Maybe it's like a village house worth 200 or 300,000. Maybe Takoradi, probably 300,000 or 200,000. No, that kind of. So it is possible for you to get one rate issued at each of them. That is permissible. But you cannot go more than the total value of the judgment debt together with the interest and the cost. So that is the point about Order 45 Rule 2. So 45 Rule 3, a party entitled to enforce a judgment or order for payment of money together with court may, if the party so elects, issue one writ of fi.fa to enforce the payment of the sum other than for costs adjudged or ordered, and a second writ of fi.fa to enforce payment of costs. So if you have judgment, two main components, if it's about money, the actual judgment money, the money that you sue, either liquidated sum or damages, or liquidated damage which have been awarded by the court. That is one. And then the cost, which has been ordered. And the cost too may not be only one. We have a cost which is awarded on the day that the judgment is given. And then we also have costs which are given as part of interlocutory. Maybe somebody came for amendment, the court granted it subject to costs. Somebody missed court, the court adjourned it and awarded costs, or something like that. So we have like a couple of costs. So at the end of the litigation, you are supposed to also list the dates. You can do what you call either you can do separate entry of costs, or can subsume the cost as part of the entry of judgment. But they have to indicate the date on which the court awarded the costs, as it were. Yes.
How about costs incurred the
process of execution? Yes. So that will be known sometimes after the process. So when the money is realized, you have to come to the disbursement of the money. So the money is not disbursed yet, but you know the cost. So the cost will be taken from the money realized. So not only cost awarded, but also cost of execution. So cost of execution. And of course, the auctioneer, if you are going to, they have like a percentage under the law. Look at the auctions say law. A percentage is given to them automatically, and that one is taken out. And if there are other things, maybe like evaluation, you have to get something evaluator to do official valuation. It's all cost, isn't it? And sometimes maybe you need assistance with the police. And they'll say that the police will not tell you, give us money. They tell that we have only one car, but the tire is fault, and then there's no fuel. So, sir, we are not able to go with our car, but we are ready to help you. I don't know how you do it, sir. It means that they are speaking to you that you need to do something. And so, so they are all part of what? They are all part of the cost as it went. So we would like to, yes.
Does it mean that you cannot recover costs during the pendency of the matter when maybe the cost is awarded until final judgment is ordered?
Good.
Or you can take it as somewhere.
Good. So you can, when the cost is awarded, you can decide to, you don't need to wait. You don't need to wait. Especially if the cost is significant. And then the other parties, for example, is uncooperative. And because of the uncooperation, it even pushes the judge to award some hefty costs. Sometimes, and that's why cost of discretion, we got that 74. And the court is there to do justice. So the court will always have regard to all the circumstances. And that is why I said that, and I want you to read that when the court is exercising discretion, the discretion must be transparent. If you are going to award costs, it's not enough for the judge to say that I've awarded cost of 50,000 cedis. It looks arbitrary because you haven't told us the things which you took into consideration. Maybe if we say that this and this and this and that, everybody will understand, okay, then the judge is within his or her discretion to award that cost, isn't it? Good. And that is why, if you look at the 74 well, but the lawyers practitioner don't use it well. If And if the judges so we don't use it, but if the court is quite heavy, you have to do what we call the taxation of costs, meaning that you have to let the parties enter the box. They found their necessary receipts and other things to prove you are going to award a heavy cost. Yeah, so there should be some basis, but you don't need to wait for the case when before you can levy execution of costs awarded in your favor, except that from a practical point of view, it may not be worth it. It may be wasting money and time. Let's assume that a cost of 5,000 is awarded in your favor, and you need to do execution. But if you waited for everything, unless you just want to vex the other party, in which case you may want to do that. Otherwise, yes.
It's actually hard to understand this question because the impression I got is that while trial is going on, you can actually go and ask for costs. If that is
No, his question, as I understood it, was that if in the course of the ongoing proceedings, like the trial, like from when you say proceeding, from the start of the case up to judgment be given, in the course of the ongoing or pending proceedings, if for whatever reason the court award costs, must the party in whose favor the costs have been awarded wait until the final judgment before he can do execution? That was a yes. Are you clear now? No, I finished.
So I got since the trial is still open.
Yes.
Why would the judge award? What would the judge?
Okay, so I'm going to answer, but I order cost of 3,000 against you. So, who are the sheriff in the court? Because you have to do execution for me. All right, that was on the lighter note. Yeah, so there are a number of reasons in which the cost may be awarded. If you remember, when we were discussing Order 16 amendment, isn't it? Yeah, sometimes somebody may object to amendment, and then the court will say, okay, we are going to allow the amendment, but it is subject to what? Subject to costs. Not only that, some other things. You want to bring application for joinder, maybe in the middle of the case, and you were the plaintiff, and you knew that this party was a necessary party, and waited, isn't it? Now, once the party comes in, it's going to change the progress and everything. So the other party may have to compensate it for by cost. So there are a number of reasons, or maybe somebody adjourned, the court is ready to go on, then you insist that the court should grant to adjournment. The court to award cost what against him for letting somebody come all the way from his house for no show, wasted the person time and energy. So there are a lot of reasons. So read Order 74 again. Very well. Yes.
From what you just said, can we say that you can have a situation where you do balance? Balance in the sense that at the point you had a cost against me as the defendant, and at the point I also had a cost against you as the defendant. And if have a situation where we get to the final judgment, where we decide, okay, fine. So have a cost of the
yes. Yes. Yes, set off. Yes. Yes, cost in cost. Yes. And that is why you don't have to rush to levy execution, because not until the case has ended, you don't know what your fate will be. So if you got one cost against me and then you're happy, you raise the question, it may well be that other costs are waiting you even more than this. And that is why you have to wait. So at the end of the litigation, then the dust will have settled. And everybody, as Ghanaians will say, will know his smoothness what level, and then you take it from there. Do you promise me that you read the whole of the 75 so that I'll just discuss with you and then leave within it with you? 45, you read it. Will you read it? Sometimes I don't trust you, that is why I have to read it. Yes. What is your pleasure? Yes, you are the conscience of the class. Right, I understand you. Yes. Good. So that is order 45, rule 2, and then rule 3. And then we look at the. Do you look at the rule 3? Yes. So rule 4, methods of putting writ into effect. Subject to the other provisions of this order and the provision of any other enactment, a writ of fi.fa shall be put into effect. A, in respect of any movable property in possession of the judgment debtor by actual seizure, the property being kept in the custody of the registrar until sale. So first of all, if you are going to do fi.fa, you target movable first. So don't go after the person's house. When you know that the person has a car, the person has got some equipment, computers and other things, these are movable, isn't it? Yes. Particularly so if the amount adjudged to be recovered can be taken care of by movables, why go after what? Immovables. So 45 refer that these movables are actually taken by force, actual seizure, and they are kept by the registrar. But in practice, the registrar does not have enough space. So we have warehouse. So we have what they call the licensed auctioneers. And then if you're a licensed auctioneer, we have some practical situation, which I'll tell you. A licensed auctioneer will have his own warehouse somewhere. And then the things will be kept there. There was a case we had. So the vehicles were taken over, kept at the auctioneer's warehouse, and then people went to steal the vehicle. Yeah, so, but if you look at once they've been taken over by the registrar, the auctioneer is an agent of the registrar, as it were. Because the registrar, which is supposed to do the execution, isn't it? And then he is only licensed to perform some of the functions the registrar is supposed to perform. 45 rule 4b. In respect of any money or negotiable instrument, by actual seizure and the money, by actual seizure and the money or instrument being deposited in the court by the registrar and held subject to the further order of the courts. Yeah, so sometimes execution may be actually compulsory taking over money. If maybe I know that you did a funeral not too long ago, you have the funeral donation box, and then the case is let's say against the family. They had the family, you have the family donation box. We just come and take the box, and then the money in it will be checked and kept by the registrar to satisfy the judgment that as it were. Or sometimes negotiable instruments, maybe like a check or some other negotiable instrument within the meaning of the Bill of Exchange Act. One of the Bill of Exchange Act at what? 55, yes. Isn't it? Yeah. Yeah, 55. Was he misleading us? No, I think it's 55. Yeah. C, in respect of any movable property to which judgment debtor is entitled subject to lien or right of some other person to the immediate possession of the property by delivering to the person in possession a written order prohibiting the person in possession from giving over the property to the judgment debtor. Please take your time, pay attention to what we're doing. I take my time to read the law and explain the law itself to you. Some of you, if I ask you to go and read it, you will not read it. If you read, you will not understand. So just pay attention. It may well be that the judgment debtor has got a property where somebody is keeping by way of lien. Remember your sale of goods law? Yes, so the person said, okay, I'm holding on to this property. This computer is yours, but because you are owing me or so whatever reason, I'm holding on to it. I won't give it to you. Until you have the sad obligation that you do what? You owe me. So that is the right of what? Lien. Now, supposing that there's a judgment against you. Now, this machine is for you, but it's in my possession now, exercising lien on it because of whatever claim I'm making against you. Now, in terms of Order 45, Rule 4C, when fi.fa is being done, execution is being done, it is permissible for the registrar to call the sheriff or the bailiff to come and have this machine seized from me. Because it's not for me, it's for you, and the judgment is against you. So when the lien is taken, it goes back to you, isn't it? So you have the right to it. So it will be taken over. But later on, there's what we call the interpleader. Later on, the person having the lien or some other claim, when it's taken over, may come to court and say that this thing cannot be sold in execution of judgment against you because I have this claim against him on it. Then the court will look into if there's merit in it, and the court will make the necessary orders, as it were. Or it may well be that the reason why I have the lien is that the person is owing you. Yes, so to still be taken, how much is he owing you? Maybe 20,000. But the property you're actually holding under the lien is probably worth 100,000. And they have the judgment debt, or maybe 120,000. The court will say that, okay, the property should be sold. Your 20,000 will be given to you. And then the rest will be used to reduce the judgment debt. So, sorry, the other way around, like maybe like the 80,000 is for me. And then we'll left with the, yeah, so whatever, the court will look into it.
What are holding more than what's not holding?
Yeah, so the court will go into it. The court will go, if the court goes into it, and for example, it is a case that because a manner of collusion, see, to guard against collusion, that is why the law is the way that it is. The court is very much aware, the law is very much aware that someone might have a lien. But we're interested in the circumstances leading to the lien. Was it before the case, which has culminated in the judgment, in respect of which the execution is being done, or it was during the pendency of the case? Sometimes someone may know that, no, the case that I'm fighting in court, the signs are not good. I'm going to lose. So you start organizing your affairs in such a way that even if you win, you are not going to have it easy in executing it against me. So all those things may be important. That is why 45 Rule 4C say that, yes, despite the fact that you have a lien, it can be taken over, isn't it? Or you can be given a notice that hold on to what you have, don't give it to anybody. So they can, by delivering to the person possession, written order, prohibiting the person possession from giving over the property to the judgment debtor. So that's another way. So sometimes it may not be like actually taking it over, but because the judgment debtor has a property over you, the registrar can serve notice on you that don't give it to the judgment debtor without further direction by the court. So that is another way. So in that respect, it has also affected the property rights of the judgment debtor. Ordinarily, because it's property, at some point it should go back to him. But because of the prohibiting notice from the court, you cannot give it back to the property owner unless the court gives further directions. So let us take note of that. Now let's look at the 45 Rule 4D. Yes.
So, at any point in time, would the court order?
for 1 second. You're going to let your mask go there so that when I see you, I can recognize you. Have you always wearing this? Or just today? Just today. Or that means I know your face.
Oh, Madam Catherine.
All right, okay, all right, go ahead. Okay, go ahead.
I want to find that so practically the court order will not override the lien.
Oh, right. It depends. It's up to the registrar. The registrar can actually order compulsory seizure, except that the party having the lien has got an interest in it. So we'll come and file the what they call interpleader notice, the notice of claim. If you look at the section 12, Rule 12, we'll come and discuss that. Yes. Yeah, so Order 45, Rule 4D, 1D, in respect of shares in any body corporate by written order, prohibiting the person whose name the shares are held from making any transfer. You see, the reason why I am particular about execution is that when you become a lawyer, all the things you'll be doing during the litigation, they don't mean anything until you can realize the judgment, isn't it? And that is why you should know enforcement of judgment well. In respect of shares in any body corporate, by written order prohibiting the person whose name the shares are held from making any transfer of the shares or receiving payment of any dividends of the shares, and prohibiting the manager, secretary, or other proper officer of the body corporate from making such payment until such further order. So another target for execution using writ of fi.fa is the shares which the judgment debtor has got in a company. When I was coming, I just got the alert on my phone, and I got different, not too much. I mean, I didn't buy much. I bought about 4,000 Ghana cedis and 920 Ghana cedis from MTN dividends. Those who bought a lot, I'm sure you are getting a good amount of money, isn't it? Yeah. So you have shares in the company. A judgment is made against you. The judgment creditor can, as part of the writ of fi.fa, target the company in which you have the shares so that the registrar will serve notice, an order prohibiting the shareholder from making transfer, particularly if the shares held in a public company. Certainly, if it's a private company, there's serious restriction on transferability of shares. Yeah. So if it's a public company, you can easily transfer the shares, but you don't want that to happen. And when you're transferring shares, you have to notify the company, isn't it? Use the common form, but you don't want that to happen. So you serve a notice prohibiting the company that should this person come to attempt to transfer shares, don't allow. So that is one. And two, you may say that no dividends meant for the shares he holds should be paid to him, to the judgment debtor, who is the shareholder. So that is another way. And then, of course, once it's that way, in future, Garnishee will also follow. Because the company is holding money belonging to the judgment debtor, isn't it, by reason of the dividend. So the company will have to come and show cause why the money should not be paid to the judgment creditor, as it were. Under 45, Rule 4(1)(e), in respect of immovable property or any interest in immovable property, whether at law or in equity, by a written order prohibiting the judgment or debtor from alienating the property or any interest in the property by sale, gift, or in any other way, and prohibiting all person from receiving it by purchase, gift, or otherwise, and the registrar may also, by direction of the courts, take and retain actual possession of the property. Yes, so if you look at it, immovable property is last, isn't it? the first target, we are talking about direct movables. Then we are talking about maybe like the money or negotiable instrument somewhere, or maybe shares, as it were, isn't it? So those are some of the things. Yes.
So in the event that, let's say a judgment debtor has.
Can you speak up?
I'm saying that in the event that.
Yes.
The person against whom a judgment has been paid.
Yes.
Has all this, but when they applied for the certificate of fi.fa,
yes,
they went straight into immovable property, and the person filed a process against it in court, saying that, oh no, I have immovables, so target my immovables first before we get to that.
No, of course, like if, for example,
The movable.
Yes, if the person has movables, and let's say that the only house he's living in is what, yes, he can go to court and raise a concern, and then you provide information of other movables that you have. And then you tell the court that, yes, I have this car, I have this machine, I have this, and it's even worth this. This is the house I'm living in, so the execution should not target the movable, since the movables are of reasonable value and they've not been exhausted. Yes.
My lord, with the greatest of respect, please, I want to find out, so who will declare those assets to the creditor?
Good. That's a good question. So let's clap for him. Let's clap for him. It's a good question. You see, when, and I'm happy you are doing this. And the procedure we are learning, as we are not learning only for exams, for example, not all of you will pass. We are learning it actually for life. When you become a lawyer, once you get your client, as part of good lawyer-client conference, especially, let's say that you are for the plaintiff, let's talk from that perspective. Now, ask the plaintiff to provide information about assets of the defendant. So the plaintiff will have to start as early as possible to do investigation, background checks about the defendant. Otherwise, if you get a judgment, the judgment you get will just be what? The paper. And can you eat a paper? You need to translate it into what? Into money. And you can only translate it into money if you know the assets of the judgment debtor. So, as part of your litigation strategy, you must also guide your client to gather information about the defendant. So that is very important. If you're also for the defendant and you're also going to make a counterclaim, you should also do the same thing. Or if you don't make a counterclaim and you want to really represent your defendant, you have to tell your defendant that if you do lose, these are some of the things which will be targeted. So maybe the earlier you the earlier you take the necessary steps. Well, I'm not telling you what you should do, but I'm not telling you what you should do. Yes.
And the plaintiff did an order to string the defendant for selling or admitting.
Good. So there's what we call order 25, preservation of property. It's part of the injunction. So sometimes, if you know that the defendant is likely to take certain steps, which would cause some irreparable damage and so on, so they want the property to be preserved, you can get the preservation what? The order, as it were. So that is important, yes.
So even if the property is not a subject of the
now, if it's not the subject, you haven't proved your claim yet. So why do you want to? Yes.
But that's the only property that you are aware of. In case you that's the only one that you are able to sell and get.
able to sell and get the money.
Yes.
Well, I mean, it's not impermissible. It's a question of you convincing the court. But it's a Herculean task in the sense that you are not looking for a direct relief against that property. And your only hope is that you may win the case. And if you win the case, apart from that property that you may sell, there is nothing that the defendant has got, isn't it? Yeah, so if you think that you can convince the court, why not? Yes. Except that if you do that, it should be subject to undertaking house damages. Because what you'll be looking for has the effect of injunction. So when we say injunction, not only where the word direct injunction is used. Preservation order is the effect of injunction. Because until it's vacated, you cannot do anything inconsistent with that, isn't it? Other will be in contempt of court. So it's a form of injunction. And then the court will have to make undertaking house damages. In other words, should it happen at the end of the litigation that you are not entitled to it because you even lost the case, unless you have the litigation drag on for about 2-3 years, you've actually prevented the person from freely disposing or enjoying the property. So you also have to compensate the person. Yes. When you ask questions like this, I'm happy that we go to 9 p.m. No, but let me take you. Okay. Yeah, so let's no, but no, if the question is very crucial, then let's take it.
What measures does the court put in place to ensure that properties that are being brought to court for such purposes actually belong to the losing party? Because there may be an instance where, let's say, you say, oh, this car belongs to that person. We grant you another offer. You go and get the car, you sell the car, and then it comes after the car is
good. So there's what they call interpleader proceedings, which we'll be discussing soon after execution. We discuss on the 48. The 48, I think. Yeah, so we'll discuss the interpleader proceedings. That is where an execution is targeting a property and somebody has an interest in it. Can the person come and tell the court his interest so that the court will release that property from execution, as it were? We discussed that. Yes. All right. All right. I mean, that's a legitimate prayer. But at 7 p.m. is not a legitimate prayer, so it was not allowed. Okay, let's take this one.
So that means that we do not necessarily have to satisfy the court by way of evidence that this property belongs to the judgment debtor before the order is made of the court. Because from what I gather, it is the interpleader.
No, but it is a risk. It's a risk you're running. You, the judgment creditor, if you mislead the registrar to go and take somebody's property, the registrar cannot be sued. Because the registrar is protected by the law, isn't it? But you let the registrar to go and take a property which does not belong to the defendant in any way. Yeah, so you have to make sure that you do the necessary due diligence. And that is why I said that it's better to do your investigation of the access or the background of the. Don't be interested in just picking your defendant. So don't pick a defendant of straw. If you are going to court, unless maybe you just want the declaratory judgment and you don't care about enforcing it, maybe you want the court just to uphold your right and you don't really need to use any of the execution processes. But if you care about execution, you have to also think of the worth of your defendant before you sue the person. And then the minimis principle becomes important. It's not every violation of your interest or right which should warrant going to court. Sometimes you ask yourself, yes, I have a case against this person, but is it worth going to court? Because if I win, can I execute the judgment? I'm going to engage lawyers and all the costs involved. Will it be worth pursuing it? So those are some of the things. And that is why ADR become important. I do not think the dispute resolution, isn't it? Yeah, so you have a 6-3, you have 5 minutes break, and then you come back at the 6-8.
Then,
Yeah, welcome back. So I'm a lady, we are continuing to good. So we're discussing on the 45 reform. A lot of interesting question came. We're looking at the various ways by which you put into effect the rate of fi.fa, the things that you can target. Although, if you look at the 45 reforms, sub-rule 1, we have a list provided. That is the A to E. Now, if you look at the list, the movables come earlier and then the immovable later. But as a matter of fact, there's no mandatory rule that it is the movables which should come first or the movables, except that at common law and also in equity, where a person has enough movables to satisfy the judgment debt. If you target the movable property and the person further goes to court and provide information about the movables, the court is very likely to release the movable attached and direct the execution to be levied against the movable. So let us keep that in mind. And another point to note is that in terms of the 45 reform sub-rule 3, that subject to any enactment, property in the custody or under the control of any public officer, official capacity is liable to attachment, execution of judgment order with notice to the Attorney General. And other attachment shall be served on the public officer. So a government property or property which is under the control of a public officer. Maybe let's say that the public officer has actually taken custody of somebody's property under a certain law, and that person also happens to be a judgment debtor. That property can be attached so long as notice has been served on the Attorney General. Now, this is different from judgment against the state. There are two things. When we're discussing judgment and other general, we talk about the state proceedings, isn't it? We talk about the certificate of what? Of judgment. If you have a judgment against the state, which you have to actually have issued themselves, isn't it? Before you can levy it. So that is different. Here, we are talking about, let's suppose that you have probably defaulted on a certain law, either tax or something, and under the relevant law, you've come to take your properties, and judgment has been entered against you, execution is being done. So long as a notice has been served on the Attorney General, the execution rates can be extended to those properties. It's different from enforcing judgment against the state. In that case, the state is a judgment debtor. We are not talking about the state as a judgment debtor. We are talking about the judgment debtor having his property in the custody of a public official, maybe under some other circumstances. So that is what we are talking about. Or let's suppose that DVLA, for example, has actually impounded your car, or you maybe some infractions or something like that. And then you also happens to lose a case. So you're a judgment debtor. And the judgment creditor is aware that you have a property which has been taken over by maybe the DVLA as a state official in their official capacity. Or even police. Let's suppose that your driver, you have a VIP bus, your driver maybe was involved in some infractions and then he doesn't have a license or his license has expired or something. So the police has actually impounded what? The car. And then you happen to also be a judgment debtor. A judgment creditor can get the registrar to extend the writ of execution to the property in the custody of the police, so long as the notice has been served on the Attorney General. And then the order of attachment also serve on the relevant public officer. So let's take note of that. And that is why Order 45 Reform 4 says that property in custodial ledges is liable to attachment by leave of the court. And the order of attachment shall be served on the registrar. Custodial ledges means that a property which is in the lawful custody, like by a certain law, whatever law we're dealing with it, a property is in the lawful custody of a public department or public official. That can become, and especially the registrar. So a property in the custody of the registrar. So maybe like the registrar are giving custody of certain properties in respect of a proceedings, and the property belongs to a judgment debtor. That can become a subject matter of writ of what? Fi.fa, so long as the notice has been served on the registrar. And then the registrar here is quite neutral. It may well be that you have a property which under appropriate court orders are put under the custody of the registrar at the commercial court in Tamale. And let's say that you also had another case in Accra, and then you lost the case. And the judgment creditor is aware that you have a property which is in the lawful custody, custodial ledges of the registrar in Tamale. That can be targeted for purposes of what? Execution, so long as the notice of attachment is duly served on the registrar at the Tamale court, as the case may be. So let's keep that in mind. Then we also have what we call the prohibitory orders. And prohibitory orders with respect to movable properties, which is not in possession of the judgment. Like we saw that not too long ago, that, for example, somebody having a lien over a property belonging to the judgment, debtor, because maybe the judgment debtor actually owes him or something like that. So he can actually also be given an order that he shouldn't release it to him. That's the prohibitory order that we are talking about. The same thing applies to the shares, which we also alluded to can be subject matter. So the prohibitory order is served on the relevant company or the officers in charge, the director or the secretary, as the case may be. And then in the case of a movable property, a copy of the order certified by the registrar shall be delivered to the judgment debtor, or if the judgment debtor cannot be found, shall be delivered to some adult person at the judgment debtor's last known place of abode or business to be given to the judgment debtor, or in the case that delivery cannot be made, shall be affixed the front door of the court building of the court from which the writ of fi.fa issued. And unless it is the same court building, to the door of the district court nearest to the movable property in question. So, if the target of the writ of fi.fa is a house or movable property, notice should be given to the judgment debtor himself. If it cannot be given to the judgment debtor himself or herself, we have to be posted on the nearest court building, the district court nearest to the particular house, as the case may also be appropriate. Now, this is very important. 45 will say unauthorized alienation during attachments. Where there has been attachment, when we say attachment, that is to say that there has been a compulsory seizure. But the seizure, since it's not movable, you cannot actually take it. So it's the notice which will have to be posted and served. So where there has been attachment, okay, I think it's done. Yeah, so 45 will say, after attachment has been made by the actual seizure or by the written order duly delivered, served or posted in accordance with 5, any alienation without leave of the courts of the property attached, whether by seal, gift, or otherwise, and any payment of the debt, dividends, or shares to the judgment debtor, during the continuance of the attachment shall be null and void, and the person making the alienation or payment shall be liable to committal for contempt of court. So where there has been attachment, in any of the ways we have seen, whether movable property has been seized or notice have been served on the party who is having custody of it, or shares, the particular company in which the judgment debtor has shares have been notified as we've explained, or the property under the custody of a public officer, and the person will be giving the notice of the attachment, as we have explained it. Where there has been attachment in any of the ways, automatically the property is frozen. There cannot be any disposition of it by way of gift, sale, or whatever. If you do that during the period of attachment, Order 45 will say is saying that it is null and what? Null and void. That is one. And there's a consequence. Apart from it being null and void, that is, the third party cannot benefit from it. The party who superintended over the sale or the gift or otherwise has also disregarded the authority of the court. And that's contempt of what? Of courts. So let's keep that in mind. Now, what happened with respect to the payment of money and process of sales? Order 45, Rule 7. The court may at any time during an attachment under this order direct that any part of the property attached, which A consists of money, or sufficient part of it shall be paid over to the party applying for execution of the judgment. B does not consist of money so far as may be necessary for satisfaction of the judgment shall be sold, and that the money realized by sale or sufficient part of it shall be paid to the party. Yes, so once attachment has been made, if the property so attached, for example, attracts money, let's say if it shares, dividends accrue to it, that is money. It will apply to satisfy the judgment debt, or if the property will have to be sold, then the sale will be made, and then the money made will be applied to satisfy the judgment debt, as it were. Rule 8. Sales in execution of judgment shall be made under the direction of the registrar and shall be conducted according to such orders, if any, as the court may make on the application of any party concerned. And then 2, unless the court authorizes the sale to be made in any other manner, the sale shall be made by public auction. An order relating to the sale may be made at the time of issuing a writ of fi.fa or afterwards. So when you apply for the writ of fi.fa, you are going to request that the writ should be issued, and that will accompany the, it will be used for the attachment, posting on the property or the notices, as the case may be. The next thing is the sale. How do you get it sold? The sale must be by public auction, means that it's open to everyone. But if you look at the auction sales law, we have auctioneers that are licensed. And so in practice, when you are requesting the registrar to issue the writ, you also suggest the name of an auctioneer. So sometimes you say that maybe so and so Max may be appointed or is recommended as appointed to supervise the subsequent public auction sale. The registrar may so grant it, and then they will take over and see to the process of the sale. So let's keep that in mind. Now, in terms of the period of notice of sale, which is very important, because if you are a lawyer for the judgment debtor, you are also interested in policing strict, what they call the compliance with the law, straight due process, that the law is followed to the letter. So that if there's any irregularity, you may want to come in and complain, as the case may be. So let's look at Order 45, Rule 9. Subject to sub-rule 3 of this rule, no sale shall be made until after at least 7 days notice of the sale in the case of movable property, or in the case of immovable property until after at least 21 days public notice, unless the judgment debtor in writing consents otherwise. So the judgment debtor is given a certain right that when attachment has made, there have to be publication of notice. If it is movable property, the period of the notice is just 7 days. Maybe car, computers, machines, and so on. But then if it is immovable, maybe house, it's 21 days. Except that the judgment debtor may elect to reduce it. If the judgment debtor agrees that a shorter period of notice should be used, that will be it. There are times I had, some time ago, we were representing a judgment debtor who he used to be very rich, but things became very difficult, and he had a very nice, just one house in a very prime area in Accra, and things have become so difficult for him that he realized that he just had to give in to the execution. But he was just pleading that they should allow him to look for a buyer to buy the property. Because if you look for your own buyer, you may get a better value than if you do the auction. Yes. So that is also there. But it all depends upon the corporation. So if you're a lawyer for a judgment debtor, you don't have to make the judgment creditor angry, so that they will have some sympathy for you and give you a bit of a respite. So the 45 Rule 9(2), where notices are made elsewhere, the notices shall be made in the town or place where the property to be sold is situated. And if the sale is to take place in any other town or place, the notices shall also be made at the place of the sale. So you don't want any secrecy as far as the sale of the attached property is concerned. That is why all these rules are there. And then the court may, for any sufficient reason, extend or reduce the period of notice in any case. Maybe the judgment debtor could, for example, go to court and pray to the court to extend the notice. And may probably even tell the court that he's confident that it may not be necessary for the property to be sold because maybe he's expecting this money. Maybe I did the investment, and an investment is maturing in 4 weeks' time. So here is the certificate and everything. So extend it. Maybe hoping that you'll be able to raise the money to make even the sale unnecessary. So it all depends as the case may be. So let us keep that in mind. Now, can a sale made after rate of the fi.fa has been issued, due attachment, can the sale be set aside? Can it be set aside? So let's look at the 45 Rule 10. At any time within 21 days from the date of sale, of any movable property. An application may be made to the court to set aside the sale on the ground of any material irregularity in the conduct of the sale, but no sale shall be set aside on the ground of such irregularity unless the applicant proves to the satisfaction of the court that he has sustained injury by reason of irregularity. Let's look at the two and then we explain. If the application is granted by the court shall make an order setting aside the sale for irregularity, and thereupon the purchaser shall be entitled to receive back any money deposited or paid by the purchaser on account of the sale, with or without interest, be paid by such parties in such manner as the court may direct. Yeah, so where there has been material irregularity in terms of maybe a wrongful attachment, maybe the property does not belong to the debtor, and then it is sold. And probably the notice, which is supposed to be, the rare owner did not even see any notice. And then no notice was actually being published, and reasonably, the rare owner could have been made aware. That can be a basis for setting aside the sale, as the case may be. Or notice was not even published at all. Or it is the case that the sale was at gross undervalue. Maybe you can establish that there was a collusion in getting a valuer to undervalue the attached property. And if you can provide other competent valuation report from proper qualified and licensed valuers, that can be a basis for the court saying that no, there was something material irregular about this a particular sale, as the case may be. I mean, quite apart from that, you need to prove that you have sustained substantial injury. It's not just crowing that there has been irregularity, just any minor infraction. Mind you, or the 81 is what is there as well. But then if you have sustained substantial injury by reason of the irregularity, then the court will look into it and provide a remedy, either by setting aside the sale completely, or making an order for resale, or the court may grant compensation, particularly where there has been a third-party intervention. Maybe like somebody came, an innocent third party came to purchase the thing, and later on the court goes into motion to set aside the sale for irregularity, and then the court is persuaded that, yes, there was a material irregularity. The court is going to set it aside, but then the third party was acting bona fides. The court may say that the money paid to him should be refunded. And then, in some cases, the court may even order that interest should be what? Interest should be paid, yes. So these are some of the things which may happen. Now, when we come and yes.
Yes. For instance, have a case where a property has been attacked by a
Yes.
and the true owner was outside the country. The person who this order was being against was more or less a caretaker who was seen by people as the owner of the said house. At a point in the proceedings, he ran away. And so the process was actually attacked to the said building on the property. No one came to say anything. And as in the steps and finally the building was sold.
Yes.
Then unfortunately this man comes from the US saying that the said person who was in the building, whom or whose death has been attached to it, was never a true owner. And so you have to read his
then I get my property from this person. My question is then what then happens to this innocent third party, as well as the defendant whose conduct caused the cause of this also gives action.
Okay, good. You see, we have a timeline, and that is why under 45 Rule 10 1 says that within 21 days from the date of the sale. And then we are going to look at when the sale become absolute, Rule 11. If you have, some fraud, we also told that the fraud actually initiates what? Everything. So if we're assuming fraud can be set up and proven, then of course, where fraud is proven, it will initiate everything. Because it's not enough. Now, was there any search done at the Lands Commission? If you're going to attach somebody's property, it's not enough to say that I park my house in front of this house, and I park my car in front of this house, so I'm the owner. No. You must actually do due diligence. You have to conduct a search at the Lands Commission, find out from neighbors who have even lived there for a long time, isn't it? You do all this to actually satisfy yourself that this property, as a matter of fact, actually belongs to this particular person. Yes. So if those things were done, I don't think the caretaker will have been presumed as the owner. Yes, but we cannot exhaust the scenarios. We need to be aware of the general principles. And then its application will be deployed on the case-by-case basis. But the bottom line in terms of the 45 Rule 10 and 3 and 11 is that if you are complaining of irregularity, material irregularity, or you are saying that it was sustained substantial injury by reason of the irregularity, you have 21 days from the sale of the movable property, within which you may bring an application to have it set aside. Now, if you don't do that, then according to Order 45 Rule 11, if no application is made under Rule 10, which we just read, the sale shall become absolute. The sale shall become, it means final. If an application made under Rule 10 is dismissed, the court shall make an order confirming the sale. So you bring an application within the 21 days. The court goes into the merits of the application and the court says that, no, what you are saying is not convincing. It's unmeritorious. So the application is dismissed. As soon as it's dismissed, the courts will make an order confirming the sale, meaning that the sale will become what? Absolute. Now, after a sale of movable property becomes absolute or is confirmed under this rule, the court shall grant a certificate to the person who was declared the purchaser at the sale to the effect that that person has purchased the right, title, and interest of the judgment debtor in the property sold. And a certificate of purchase granted under this rule is a valid transfer of the rights, title, and interest of the judgment debtor in the property sold. So when we ask you, when does a sale and the rate of fi.fa with respect to movable property become absolute? You know what you're talking about? Two scenarios. Either by default, automatic operation of the rule after 21 days. If no application brought under rule 45 Rule 10, they become absolute. Or a application is brought, but then application is dismissed, and then the court confirms the sale. It also make it what? Absolute. And then we also told that once the sale is confirmed or the sale becomes absolute, then there should be certificate of what? Purchase. And that certificate of purchase operates as a valid transfer of what? Interest. And then that has effect of as if you've done the conveyance or whatever. There's a valid interest of transfer. And if you look at the Land Act, that can even be recorded in the records of the Lands Commission. to let everybody know that by a particular judgment, you are the owner of this particular interest now, isn't it? Now, what about delivery of the property sold? Let's look at the 45:12. No, the rules are not many. We'll finish very soon. Yeah, so, yes. Rule 11.2. Okay. If an application is made under Rule 10 is dismissed, the court shall make an order confirming the sale. Oh, right. Yes. You can appeal it. You can appeal it, and then once you appeal, you may want to get the stay of execution. And then you ask yourself, is executable order? Or sometimes what's called the suspending, you may want to have a suspension if it's not executable in a sense, as it were. If it's not granted, automatically, but if you succeed in appeal, then everything will be reversed, as the case may be. But where you have a genuine case, it's not unlikely that the court will refuse such what? An application. The court is there to do justice. The court is there to do justice. And I can say that about 98 to 99% of the time, we have very good courts and very good judges. Some are bad, but those who are bad, they are not more than 1% in my view. At least for the time of being on the bench for almost 4 years, I can say that a good number of the judges are very good people, meaning that where you have a good case, you will definitely have the case what? If you bring application to set aside the sale for irregularity and there's merit in it, no serious court or judge will say no, isn't it? Yes, so as it were. So let's look at the 45:12. Where the property sold consists of movable property in the possession. No, mind you, we finished the movable. We are looking at the where it is movable. So where the property sold consists of movable property, possession of the judgment debtor, or to the immediate possession of which the judgment debtor is entitled, and of which actual seizure has made, the property shall be delivered to the purchaser. So we are looking at the situation where maybe certain properties are under the possession of the judgment debtor, or if not his immediate possession, is somebody's possession, but he has control over the person, so that he can just order the person to let him have it. That's immediate possession. A sale has taken place, so property is no longer in him. By reason of Order 45, Rule 12(1), the property will be delivered to the purchaser, as it were. Then where the property sold consists of movable property to which judgment debtor is entitled, subject to a lien, a right of any other person to the immediate possession of the property. Delivery to the purchaser shall, as far as practicable, be made by the registrar, giving notice to the person in possession, prohibiting the person in possession of the property from delivering possession of the property to any other person except the purchaser of it. So the Order 45 Rule 12, 3 scenario will, let's say, arise. Sub Rule 2 scenario will arise, where we saw previously that if you have movable property and someone has a lien over it, the registrar, as part of the writ of fi.fa, may, for example, serve a notice on you that don't give it to the original owner until the court otherwise directs. And let's suppose that the registrar has gone ahead to let someone purchase that property. when it was still under the custody of whoever had the lien. So now it has to be released to the purchaser. So the registrar can just authorize the person having the lien to release it to the purchaser direct, or to bring it to the register, and the register will hand it over to the purchaser as the case may be. But in reality, the proper thing is for the registrar to actually take over from the person having the lien if he actually wants to go ahead and do the sale. So that when the sale is done, because if somebody is going to buy, if you advertise, the person will have to see, isn't it? So if you advertise, if it's still in somebody's possession, they have to go to where it is to go and inspect before they will decide whether to buy or not. But then if you've taken over completely, they're giving it to maybe a licensed auctioneer in the auctioneer's warehouse or designated place, it will be easier for everyone. Sub-rule 3, if the property sold consists of movable property in the possession of the judgment debtor, or some person on the judgment debtor's behalf, or some person claiming under a title created by the judgment debtor after attachment of the property, the court shall, on the application of the purchaser, order delivery to be made by putting the purchaser or any person whom the purchaser may appoint to receive delivery on the purchaser's behalf in possession of it, and if need be, by removing any person who may refuse to vacate the property. So order 45 with 12.3 is speaking to where there has been a sale of movable property, the defendant, judgment debtor, as the case may be, is still in possession, or some other people are still in possession. They be given notice and they are not vacating. They can be removed forcibly from it, and then the person who purchased it to be put in what? In possession, as it were. Yes.
So if after you go through all this process, and the person who appears to be someone who has money or something, at the end of the person has nothing, is a man of strong, then what then is the essence of
the litigation? Yeah, so that's why, and that is why you are dominus, no, what do you call it? Before you become a dominus litis, no, you are picking your defendant, isn't it? Nobody will say that go and sue this person. You were setting yourself, someone else will say it in Ghana, and then you decided that this person has violated my interest or rights, so I want to sue him or her, isn't it? So for you deciding to sue the person, and that is why I'm saying that if you are a mature litigator or a litigant, you must also be interested in the worth of the defendant. So what is the end game? The end game of litigation is that you win. So if you win, how do you enjoy the win? Execution, isn't it? Yes, so you have to think of that.
My God, I know almost all his properties are in the name of his children and mother.
Yeah.
So in your mind, you know that this man is very rich, he has this and that is your research you have done. But after the search and everything, you realize that even the cars he has are not in. You probably would have done your background check to know that.
And now you know that we've learned from the 45 that shares can also be a target of what? Of execution, isn't it? So we realize that he has a shares maybe in MTN, he has a shares in a particular company. You can also target it. Resulting trust, so that you become who will be the beneficiary.
The property is in your children.
Oh, as to whether that can be targeted.
Yeah.
Are you the owner? Are you the beneficiary? You have beneficiary interest for the title. That's what they do. Yeah, so when you are litigating, you must actually be interested in these matters. But the good thing is that if you get judgment does not expire, except that you have to go to court to get a leave. But you can get a judgment against someone when the person is not dead. I mean, if the person dies later on, you can be looking for his property. And then you get execution against his estate. Yes.
Maybe at a time when you had judgments in your favor, you didn't have enough property, you didn't have enough property for you to not be able to enforce. But then the person dies, and then
The person dies and is what? Yes, please, let me hear you. Yes, what did you say? Yes. Can you? All right, that's an interesting question. So you had a judgment against Mr. B, and then Mr. B died. Then during the funeral organized by Mr. B, the funeral donation which came, can that be target of the execution of judgment against Mr. B? So question is, the donation, does it belong to Mr. B? No. Head of family. It's a family property. Yeah. So you cannot target it. Yes. But please, I'd like you to look at order 44 root 3. We come back to the and continue. Order 44 root 3. Yes, because of the question our friend asked. Order 44 root 3, rate of execution in general. So 44 root 3, a rate of execution to enforce a judgment or order may not issue without leave of the court in the following cases. A, where 6 years or more have elapsed since the date of the judgment or order. So let's say that I said that once you have a judgment, the judgment does not expire, isn't it? So from the date of the judgment up to before 6 years elapsed, you can use the various methods of what? Execution as of right. But then after 6 years of the judgment, if you need to still enforce or execute the judgment, you have to go to court and get what? And get leave. B, where any change has taken place, whether by death or otherwise, in the parties entitled or liable to execution under the judgment or order. So let's say that the victorious party, that is a person whose favor the judgment was made, is dead. But the judgment is still part of his estate. You need to go to court and get leave. And of course, it's the personal representative who may be acting, isn't it? Or the losing party, the judgment letter is dead. You have to go to court and get a leave, as it were. D, C. But then we skipped the, yeah, then we haven't skipped it. Where the judgment or order is against the access of a deceased person coming to the hands of his or her executors, administrators, after the date of the judgment or order, and it is sought to issue execution against the asset. So let's suppose that you have a judgment against someone who has died later on, and of course you got a judgment before he died, and when he died, you've seen that he has a certain is it a life insurance or something like that, and some other pension, and all these monies are going to hit the estate. You can come under order 44 with 3, 1C, in order to get leave and levy execution against those monies, as the case may be. Or D, where under the judgment or order any person is entitled to leave, subject to fulfillment of any condition which it is alleged has been fulfilled. That will depend upon what the judgment says. If the court says that somebody should do certain things and the person has not done it or has done it, and you need to do execution, you need to go to court and actually get leave. And where any goods to be seized and the rate of execution are in the hands of a receiver appointed by the court or sequestrator. So if a receiver has been appointed, especially let's say under, let's say a floating charge, there has been crystallization, meaning that a receiver has been appointed to take over some assets of the company over which the charge has crystallized. You cannot on your own have a rate of execution, rate of fi.fa issued against it without going to court to get a leave first. So if the court grants you the leave, then you can do that. Or where someone disobeyed the court, maybe contempt proceedings, and sequestration was made. So a sequestrator was appointed to forcibly take things belonging to the person as part of maybe the contempt proceedings. And you need to later have a rate of fi.fa, as it were. You need to go to court and get a leave before you can do that. So let's keep that in mind. So I hope that answers your question, except that the rules do not know the funeral donation concept. But I think it's a subject matter worth looking into. But the law is that when a person dies, the person's corpse is the property of the family. It's not part of the estate of the person. And then the funeral too. You disagree? Yes. That's why they're making the donation.
The donation goes down.
Oh.
All right, thank you. That's very interesting to note. Okay, so that's noted. Okay, please, because of time, let's quickly jump to Rule 13. You read the rest here. Rule 13. 45, Rule 13. If the endorsement, transfer, or conveyance of the party in whose name any negotiable security or any share in the body corporate is standing, or in whom any mortgage or equity of redemption is vested, is required to transfer, the registrar may endorse the security or share certificate or may execute such other documents as may be necessary to transfer it. So it may well be that you have shares and then the shares have been valued and it's quite substantial. Let's say that they are very well-performing companies and you have shares in them and they are quite substantial. They are sold to you, so you become like the share owner as part of enforcing the judgment against the judgment debtor. The company will have to now register you as the new shareholder. So this is where Order 45 Rule 13 say that the transfer document will have to be certified by the registrar. And we have like the format. If you look at that 45 Rule 13(2), the endorsement of execution shall be in the following form or to the like effect. A.B. by C.D., Registrar of the High Court in so and so region, in action of E.F. against A.B. No, so that will have to appear as part of it. And then until the transfer of the security or the share, the court may by order appoint some other person to receive any interest or dividend due on the security or share and to sign receipts for it. So, as part of the execution, the court can say that all dividends which will be paid in respect of shares that the person has in a particular company should be paid into maybe sometimes even an escrow account or designated account or to someone appointed for that purposes. So there are a number of possibilities when it comes to execution of judgment. That is what we should appreciate from what we'll be talking about so far. let's look at order 45 through 14. If the amount adjudged with costs and all charges and expenses incurred by the attachment is paid into courts, or if the judgment or the order is otherwise satisfied or vacated or set aside, an order shall be made, an order shall be issued for the withdrawal of the attachment. Yeah, so sometimes execution is set in motion, but the judgment debtor would hurry up and go and look for money to come and pay the judgment debt and whatever expenses which have been incurred so far. When that is done, the execution will not proceed. The attachment will be discharged or vacated as the case may be. And that is why maybe a judgment debtor may go to court and ask the court to extend, let's say, the 21 days if it's movable property, or the how many days for movable, 7 days, or because he's trying to get the money so that it's not necessary for the sale to go ahead as the case may be. Then if the execution debtor so wishes and deposit in court the sum sufficient to cover the expenses, an order shall be issued in the same manner as prescribed before in this order, withdrawal of the attachment, and such steps shall be taken as may be necessary to stay further proceedings in execution of the judgment or the order. So it's not enough for you to pay the judgment debt. Some expenses have been incurred. Auctioneer have been appointed and he expects his payment and so on. So having done all that, for you to come and say that, oh, here's the judgment money, you prevented him also from earning his what? Earning his fees and some other expenses, valuation and so on. So if you get the judgment debt, you must also show that you are ready to pay the other incidental administrative expenses before the court will vacate the attachment. And finally, order 45 rule 15. Where a judgment is given, an order is made for payment by any person of money, and the court is satisfied on an application made at the time of the judgment, or at any time thereafter, by the judgment debtor or other party liable to execution, A, that there are special circumstances which render it inexpedient to enforce the judgment or order, or B, that the applicant is unable from any just cause to pay the money, then notwithstanding anything in Rule 2, while you are happy that the person said you cannot pay the money, notwithstanding anything in Rule 2 or Rule 3, the court may, by order, stay the execution of the judgment, or by writ of fi.fa, either absolutely or for such period, and subject to such conditions as the court considers fit. So here we are talking about application for stay of execution. So stay of execution, of course, we have a stay of execution where you have filed appeal. So you have a stay of execution pending appeal. When we're discussing appeal, we'll talk more about that. But outside appeal, it is also possible for the court to stay execution. Because staying execution means that you suspended execution. Yeah, so there are a number of circumstances, either installments, or as I said, you try to tell the court that, oh, the judgment is for 2 million. I have a 5 million investment, which will mature in 6 months' time, and here is the certificate. So please don't allow the execution to do what? To go ahead. And if any accruing interest can be taken care of even by the money, and there will still be more left. So that is a special one. circumstance which render it inexpedient to enforce the judgment, as it were. Yes.
With the condition that is it stay of my faith or stay of execution? Because my understanding is that execution means you are enforcing the judgment. So if you want to come saying that, oh, you have money somewhere, and they would work very soon, and then you will use that.
Yes.
Then it means that you are putting for time for the judgment to be enforced.
Yes.
But then
To be stayed.
Stay. But if you say, no, I'm saying it, for which reason they shouldn't sell the property that they want to sell, or so is it the stay of I say or is stay of the?
Okay, good. Fi.fa is a species of what? Execution. Yeah, so the same thing. Stay of execution, except that here, or the 45 speaks to rate of fi.fa. And that is why the rule is explicit on what? On fi.fa. But if we're discussing other modes, that will have also been indicated. But the 45 speaks to rate of what? Fi.fa. So it can be stayed. If you can demonstrate special circumstances, as in expedient, like the example I gave, or the one which your friends were laughing, that the applicant is unable for many just cause to pay the money. No, but don't forget, there's a law, one we call bankruptcy, personal insolvency. We have the Insolvency Act. That, I'm not talking about the corporate restructuring insolvency act, that one is corporate. But we also have insolvency law, which was personal insolvency. That law has been there, I think, since 2006 or something. You can just check it. Yeah, it's an old law. But because it's not taught in the law schools and people also don't use it, the thing is not there. It's there. Where you can just raise up your hands and say that life has become so unbearable for me. So please, don't harass me. Release me from burdens. I'm sorry, I've not run my first well. Yeah, so I'm bankrupt. So please. So you can do that. So you surrender. So when you do that, they'll have to appoint an official, either trustee in bankruptcy, somebody to take care of. You are saying that you cannot manage your affairs. So you are creditor unworthy, so you cannot manage your affairs. So somebody will be appointed to manage you. You cannot incur any credit, any debt, and so on. So if that is the case, you can be, the judgment may not be enforced against you for the period that you are under the bankruptcy order, as it were. So an application under this rule may be made, notwithstanding that the party liable to execution did not file appearance in the action. So if it's been a judgment in default of appearance, you can still go and ask for stay, as the case may be. The application, if not made at the time the judgment is given, or order made, shall be supported by an affidavit made by on behalf of the applicant, stating the grounds of the application and the evidence necessary to substantiate them. Where such application is made on the ground of the applicant's inability to pay, the affidavit shall disclose the applicant's income, the nature and value of any property of the applicant, and the amount of any other liabilities of the applicant. So where you are saying that you cannot pay, you don't just say you have to show it. You have to pull your income. Any property, you pull your income, say that maybe the judgment debt is for 200,000. My monthly salary is just 500. No, you say, what is the national minimum wage? What is it? So let's say that your monthly salary is after tax, it's just 1,200 Ghana cedis. And then your rent is 200 Ghana cedis. You have 2 wives, and then you have 6 children. They have 6 children, and then the children are all in school. Your wives are also housewives. They don't work. So you are trying to prove to the court that you have no ability to. Yeah, so under 45 rule 15 5, where the application is not made at the time the judgment is given or order made, notice of the application and a copy of the supporting affidavit shall be served on the party entitled to enforce the judgment or order, not less than 4 clear days before the day named in the notice for hearing the application. So, of course, the judgment creditor may also file affidavit in opposition and say that what you said is not true. He's only done his check. That to even eat at this restaurant, you travel by business class. You did do. So you are lying to the court that you are not a person of what? Or substance. And then the court would disregard your application. So under 45-15 rule 6, sub rule 6, another staying execution under this rule may be varied or revoked by a subsequent order. So your question, you see that order 45 rule 15 says is now talking about stay of execution simplicity. Yeah, so it's all the same thing, whether staying the rate of fi or staying execution. It all means the same thing. Yes, please. Yeah, the Insolvency Act, the personal one, yes.
So, suppose, let's say the person actually maybe has a 2-bedroom house where he or she is living with maybe the family. And then, you know very well that if you purchase, let's say, that house is full, you can pay for the judgment, bills. But then out of public policy, the fact that maybe the person has children, wife, and that is the only house that they are living, and it's not right for people to live on this program. Can you make an argument to that as a matter of human rights? Because you have the as part of public policy, you cannot stand on the street, you have to have a place where your public is. So the house cannot be. Like, this is that argument that
No, I'm not aware of any law which says that if you have only one room, it cannot be attached in execution of what? Of judgments. But just before we leave, there's one thing, a question came. That how will you know that the judgment debtor has got certain money somewhere? Now let's look at order 46, examination of judgment debtor. It's very important. There's 2 rules. Now we'll go and discuss Garnishee. Yeah, so examination of judgment debtor is a very important rule. Order 46, rule 1. Where a person has obtained a judgment order for payment of money by some other person, even after referred to as judgment debtor, the court may, on an application made ex parte by the person entitled to enforce the judgment order the judgment debtor, or if the judgment debtor is a body corporate, an officer of it, to attend before the court and be orally examined on the questions: A, whether debts are owing to the judgment debtor. B, whether the judgment debtor has any property or other means of satisfying the judgment or order. And the court may also order the judgment debtor officer to produce any books or documents in the possession of the judgment debtor relevant to these questions at the time and place appointed for the examination. Another under this rule shall be served personally on the judgment debtor and on any officer of body corporate to attend for examination. So we are going to discuss Garnishee very soon, but where money is supposed to be paid, you have a judgment debtor. You have no idea whether he has monies and so on, and then the ability. The judgment debtor can be ordered by court to enter the witness box. You actually take oath and will be examined by, let's say, the judgment creditor's lawyer to find out whether he owes anybody, whether he has monies anywhere, and so on and so forth. And since you're under oath, you cannot lie. Well, if you lie, that is what? Perjury. Then you find out the accounts, the banks you have accounts, and so on. And all those things are important because to help the judgment creditor to know where to target Garnishee proceedings. We have to know where he has money sittings, isn't it? You don't have the information. So, but the 46 will allow you to get him to come to court. You will take an oath. Then you examine him. You examine him concerning properties and other means that he has for satisfying what? For satisfying the judgment debt, as it were. Let's look at what it says too. Where any difficulty arises in or in connection with the enforcement of any judgment order, other than a judgment order as mentioned in Rule 1, that is a Garnishee one, the court may make another under that rule for the attendance of the party liable to satisfy the judgment or order, and for the examination of that party on such questions as may be specified in the order. And that rule shall apply accordingly with the necessary modifications. So Order 46 is not only speaking to where you are making use of Garnishee, all the circumstances under which you may need to deploy the execution of judgment mechanisms, you can make use of it. So you get the judgment, because that is the only way. You get the judgment debtor to be put in the box. And these are not applying to defendants, those apply to plaintiff as well, because their judgment what? Debtor. The judgment debtor is anyone in respect of whom the judgment debt is supposed to be satisfied, as it were. So I give you, this time not 5 minutes, I give you 3 minutes break, and then we start discussion of Garnishee proceedings. So that's why don't go out. So we want to continue with discussion of Garnishee proceedings, Order 47. And just before we had a break, we talked about Order 46, about examination of a judgment debtor, where you can actually file a motion and then get the court to grant an order directing the judgment order to attend proceeding on a scheduled date. The person will actually be sworn, and you can interrogate the person, the view to trying to find out whether he has property or he has some money sitting somewhere, and all those things will give you the information as to where to target for purposes of what? Execution. I want to talk about Garnishee proceedings. So when we say Garnishee proceedings, what is it? Garnishee proceedings involve attachment of debts owed to a judgment debtor by a third party with a view to diverting those funds to the judgment creditor in satisfaction of the judgment debt. So this is how it is. If you like, we have judgment, we can just use that, okay. You have a judgment debtor. You have the judgment creditor. And then we have the third party. And the third party has money belonging to the judgment debtor. So, in a sense, the third party owes the judgment debtor. But the judgment debtor is owed by the third party. You understand? So the third party is called the Garnishee. Now, the judgment creditor has money judgment to enforce against the third party. I mean, not the judgment debtor. And this judgment debtor has got money to his credit, standing to his credit with the third party. So the Garnishee proceedings will allow the judgment creditor to go straight to the third party, bring the third party to court, and then let the third party come and show cause, provide reasons why the money that he is having belonging to the judgment debtor should not be paid to satisfy the judgment debts which the judgment debtor owes the judgment creditor. I mean, basically, that is what Garnishee proceedings involve. So attachment of debts owed to a judgment debtor, as we've explained, by the third party, with a view to diverting those funds to the judgment creditor in satisfaction of the judgment debts. So unlike fi.fa, which operates in rem, in a sense, against the property, Garnishee operates in personam, so to speak. And also, it operates in tangible rights. That is, the debts shows in what? Action. So Writ of fi.fa is more shows in possession, so to speak, because you take. But this one is like it operates against intangible rights. That is a debt, which is shows in action. So a typical example would be money held in a bank account. So the third party may be like a bank. The judgment debtor has an account with this bank. He has money in it, as it were. Or salary owed by an employer. Maybe the third party is an employer of the judgment debtor. So the salaries that are supposed to be paid to him. Or that's due under contract. It may well be that there's a contract between the judgment debtor and then a third party. And the third party is supposed to pay some monies to the judgment debtor. So these are all some of the situations in which monies owed to the judgment debtor by third party may arise. So as we said, the statutory framework is order 47, and the judgment creditor will initiate the process and seek satisfaction of the judgment. And the judgment debtor is the original debtor whose funds are targeted. But the funds targeted actually belong to the judgment debtor, whether being a bank account or being a salary or being monies from a contract. And then the Garnishee is the third party holding the money belonging to the debtor, as we've explained. Other banks, employers, business associates, as the case may be.
My lord.
Yes.
So if the salary account is Garnishee, and let's say the organization is not in the country, can they pass the money to another entity so that they pay their salary with that amount that's of course?
I mean, say it again.
My lord, I'm saying that.
Because you covered your face, I have to hear you twice so that I hear you.
I'm saying that.
Okay.
If the salary account has been Garnishee, and let's say the organization is an international one, and because of the salary account has been Garnishee, the account cannot be paid, and they pass the money through another organization or entity to pay their staff, would that amount to contempt of court?
Yes, if the evidence can be established. If the evidence can be established, that can be contempt of court. But then again, it also comes to the fact that the jurisdiction of the court is territorial. So things which were done outside Ghana, if we can establish it, if we cannot establish it, then it may not give rise. It depends upon the situation. So to depend upon the circumstances of the case. Now, just before we look at the law, I'm sure you read yourself. Garnishee involves two-stage process. Two-stage. The first one is what we call the Garnishee order nicely. Garnishee order nicely. That's a provisional order will be made, directing the Garnishee. And now, if I say Garnishee, you know what I'm referring to. Who does not know the Garnishee I'm referring to? The Garnishee is a third party having money which belongs to the judgment what? Debtor. Yes, so a provisional order is made directing the Garnishee to show cause why the debt owed to the judgment debtor should not be paid to the judgment creditor. So usually it will be ex parte application. Ex parte application which will be made by the judgment creditor. You know, now if I say ex parte application, you know what I'm talking about. Good. So you have your motion paper and then accompanied by affidavit in support. The motion paper, you simply request the court to make the order directing the named, Garnishee. So here, the Garnishee is not a party to the suit. It's not a party to the suit. So you go to court and you make the application and say that you have information, yes, you have a judgment, of course, you identify the judgment. You have a judgment against the judgment debtor. And then you have a reliable information that the judgment debtor has money with named third party or Garnishee. For that matter, you want the court to order the third party, the Garnishee, to come to court on an assigned date or appointed date, to come and prove to the court why the money they are holding in the account of the, to the credit of the judgment debtor should not be applied in satisfaction of the judgment debt. So to be ex parte, and then once you obtain it, you go and serve it on the Garnishee, the third party. And of course, if you can also even serve it on the, or they could serve it on the judgment debtor as well. So on the assigned date, now just before that, once the order is served on the Garnishee, it temporarily attaches the debt, meaning that it freezes the money. The Garnishee cannot allow the judgment credit debtor to release the money. If it did that, that is contempt of court. So as soon as the order is served on the Garnishee, until you go to court for the court to discharge you or release you, you have to let the accounts remain in the frozen state, as it were. Then we also have the second stage you have to call the Garnishee order absolute. So we have the first one, Garnishee order NISI. And some will say NISI, but not NISI. Garnishee order NISI, N-I-S-I. And then Garnishee order absolute. So Garnishee order absolute simply means a final order directing the Garnishee to pay the attached debts or part thereof to the judgment creditor. So the Garnishee order absolute will be made where the Garnishee fails to show cause, that is a third party having the money, was not able to explain to the court why the money should not be paid. Maybe if he has some legitimate reason, yes, I have money belonging to the judgment debtor with me, but due to XYZ, this money should not be given out. Because maybe the judgment debtor has probably taken a loan from us. Now, those in the banks, there's a funny development. There's something they call the cash lien as a security, isn't it? Do you have bankers here? Yes, cash lien. Why do you take a? I used to, for 15 years, I think I was on the board of a rural bank. Of course, I'm also a good shareholder of that bank, or the Tobu Rural Bank. And one practice I observed was that there's something they call lien on cash or something. You go and take a loan, and let's say you are taking a loan of 100,000, and we'll say that they're keeping 30,000 as what? I said, it doesn't make sense, doesn't it? If the person needs the money, that's why it's coming for the loan. And then you say that no, the 100,000 you are looking, no, we are holding on to 30,000 as a security. Well, I mean, that is the bank, that's what they do. That's why it's difficult to.
You pay the interest on.
You pay the interest on the 30,000 that they are holding on to as well. Yeah, so if the Garnishee fails to show cause, that is to satisfy the court why he should not make the money available, then the court will order the Garnishee to actually pay the money to the judgment creditor. So the Garnishee will be made absolute. It will no longer be what? Nice. So the effect of the Garnishee being absolute will simply means that it transferred the debt obligation from the debtor to the creditor. And then the Garnishee, the third party discharges, is relieved or released upon payment. So basically that is what it's about. So once you have that understanding, we can look at the law quickly. Let's look at the order 47, the law itself, and we have the working understanding. So where a person in this order referred to as judgment creditor has obtained a judgment or order for the payment of money by some other person referred to as the judgment debtor, and the judgment or the order is not for the payment of money into court, and another person within the jurisdiction referred to as the Garnishee is indebted to the judgment debtor, the court may, subject to the provisions of this order and of any enactment, order the Garnishee to pay the judgment creditor the amount of any debt due or accruing to the judgment debtor from the Garnishee, or as much of it as is sufficient to satisfy that judgment or order and the cost of the Garnishee proceedings. That's why, as we explained, that is it. The judgment debtor has money with the third party, known as the Garnishee. Then the creditor will take steps for the third party to be brought to court. And then the court will order the third party Garnishee to either pay the whole of the money to be enough to satisfy the judgment debt, or only part of it, if only part will be enough to satisfy the judgment debt. So let's look at 47(1)(2). Another under this rule shall in the first instance be an order to show cause, and shall specify the time and place for further consideration of the matter. In the meantime, attach such debt as mentioned in sub-rule 1, or as much of it as may be specified in the order, to satisfy the judgment or the order mentioned in that sub-rule and the cost of the proceedings. So that is the two-stage approach, the order nice and the order absolute, as it were. What is the procedure? The procedure for making it 47(2). Application will have to be made ex parte, as we indicated. So the application, this time, there will be no, only you, the judgment creditor, making it. And your affidavit must identify the judgment or the order. So the entry of judgment, which you have, will have to be exhibited. The entry of judgment will have to be what? Exhibited in the affidavit. So you have to keep that in mind. And then you must also state in the affidavit how much of the total judgment debt remains unpaid. It may well be that part of it has been paid. So you have to tell us how much remains outstanding, the affidavit. And then you must also state that to the best of the information or belief of the deponent, the Garnishee is within the jurisdiction and is indebted to the judgment debtor, and state the sources of the deponent's information or the grounds for the deponent's belief. So the third party, a friend, the third party should be in the jurisdiction. That is, the Garnishee should be in the jurisdiction, not outside. The reason being that there could be contempt, isn't it? If the person outside the jurisdiction, you cannot deploy the contempt jurisdiction of the court today. Now, 47 Rule 3. An order under Rule 1 to show cause shall at least 7 days before the time appointed for the further consideration of the matter be served on A, the Garnishee personally, and B, the judgment debtor, unless the court otherwise directs. So this is important. The notice, you went ex parte. The court granted you the order you needed to serve on the Garnishee. Now, that notice should also be served on the judgment debtor. And if you don't, later on, the judgment debtor will come and complain. And the court may probably even set aside the whole thing, as the case may be. Service of the order shall bind the Garnishee as from the date of service on the Garnishee of any debt specified in the order, or as much of it as may be specified. That's why we said that once the Garnishee is served, it freezes the amount and then cannot be paid to third parties. Now, what happens on the day assigned for the Garnishee to come to court? So the 47 Rule 4, where on the further consideration of the matter, the Garnishee does not attend or does not dispute the debt due or claim to be due from the Garnishee to the judgment debtor, the court may, subject to Rule 7, make another absolute under Rule 1 against the Garnishee. So as a general rule, on the day assigned, once there's evidence that will be served for the Garnishee order, the order nicely, with the dates on which you are supposed to come to court, and let the court know whatever money you are having and whether the money should be released or not, should not be released. Once you've been served and you don't come on the appointed date, the court can go ahead and make the order absolute, in which case the court will now order you. This is not to show cause. The court will order you that pay the stated amount to the judgment creditor. And if you don't do that, you're in contempt of what? Of court. Yes.
There are times when the Garnishee, they appear and then explain to the court, will give evidence as to what amount there is to account. But we went to court and then dollar accounts and CD account, $1 and then some few cents. And then the CD accounts, 1 CD. So if that Garnishee does not appear, and then God places an order for an amount to be paid, and then there's no money there. What that?
Good. So,
yes, I'm few books and $1.
and you for institutions, they always attend. It's individuals that may get this situation, but for institutions, banks, they always go to court. But for individuals, if you don't go, then the amount settled in the order, you have to pay it. Because why didn't you come to court to tell the court that, oh, this person doesn't even have any money with me, but the money he has with me is just 10 cedis.
My lord.
Yes.
So what if transactions were made after judgment has been entered? Can the court order the third party? Like judgments were made, but the judgment debtor order the third party to make those transactions from the account.
No, that's what we're saying, that when the order nicely is served on you, the Garnishee, be the bank or whatever, as soon as you are served the order, from that moment, you should not respect any order by the judgment debtor regarding the funds you are holding on his behalf.
I just put it in a nice way. No, the judgment debtor ordered
The third part, the Garnishee, yeah.
to transfer those funds.
Yeah.
Before the judgment creditor serves him with the.
Of course, the Garnishee is not aware.
Yes.
He's not a Garnishee until he's served with the Garnishee order nicely. Because he's not aware that the court has made any order that he should come to court and show cause, isn't it? So there's no problem.
The lawyer would have taken steps.
But then if, after being said, they go ahead and do anything, then that one is contempt of court. So that is how it is. And that is why, for good reasons, you see the Garnishee nice is supposed to be as party. Well, you want to take them unaware. Because if it's on notice to the judgment debtor, you quickly issue checks to clear all money from the account, isn't it?
Yeah.
Or if it's on notice to the Garnishee, the Garnishee bank or institution, because they may have a good relation with the judgment debtor, they may tell him that, hey, go, this is what you receive. Oh. It's up to you. That's what the court says. So what should you do? Well, we've told you. There can be that collusion, isn't it? Yeah. But you don't want that to happen. And that is why it should be on the quiet. So when they are aware, then it's also frozen immediately. You cannot do anything until you've gone back to what? To court. I noticed all of you have taken about 15 minutes of my time. And from my, yeah, it's true. Anyway, you go ahead. No. No, once it's a minute, let's hear it. Yes.
And data can go back. And also that's another account like credit balance. And by the time the Garnishee on that account, they decided to start off quickly before they implement the night side. For instance, I didn't go. Yes. Because the weather was pay money.
No, I didn't hear you well, but if my understanding is that before they were served with the order nicer, before they were served with the court order. Yes. Yes.
Upon the service of the night time, the Garnishee realized that that will be virtual debt because they garnish
yeah.
Trying to set off and then report only 2 million to the court.
No, from the moment that you are served, you cannot do any transaction. I mean, either yourself as a Garnishee or even the judgment debtor who has the funds that you are holding, you cannot do anything. If you do that, you're overreaching the court. And so that's why the showing of the cause, you may set up some of these reasons. You go to the witness box, you go with the requisite books, a loan accounts, a loan contract and all that. You go with it and show to the court that, yes, he has money, but this is also outstanding what? Obligations to us, yes. Yeah, so thank God you fit in 20 minutes already. Okay, let's take a question. Let's hear her. Please, let's have silence and hear her. Letters of credit.
let's say it was set today or yesterday to pay the else was due to the payment. It's a liability that you already promised the other the supplier
Yeah.
to be
Yeah.
paid. And
With that amount contempt.
yes,
Now, that is why, for good reason, the law says that come and show cause. Come and show cause simply means that now you'll be served with this order. Come and explain to the court why you should not be forced to pay this money towards satisfaction of the judgment debt. So the why may be part of what you are saying. You understand? We're not saying that once the Garnishee order is made, automatically the court is going to say that pay the money to judgment creditor. No. You want to find out, is there any reason which lawfully can prevent the money which you are holding for on behalf of the judgment debtor to be applied in satisfying the judgment debt? So the burden is on you as a Garnishee to actually satisfy the court with respect to the explanation. If you cannot, then what it means is that the debtor has got the free money with you, which you can get at any time. Then the court will order you to pay to the judgment creditor. So please, let's look at the 5. What is order 47 rule 5 of CI 47? It's beautiful rhyme, isn't it? Order 47 rule 5 of CI 47. Good. Yes. So where on the further consideration of the matter, the Garnishee disputes liability to pay the debts due or claim to be due from the Garnishee to the judgment debtor, the court may summarily determine the question in issue, or order that any question necessary for determining the liability of the Garnishee be tried in any manner in which any question or an issue in any action may be tried. So you are coming to show cause, and then showing cause, you set up explanation, which is in effect objection to what the court is saying, that no, you shouldn't be made to pay the money towards satisfaction of the judgment debt. And then the court is also not, the other party, the judgment creditor is also disputing that no, there's a collusion between you and the judgment debtor. That is why you are trying to put up this. If the court cannot determine it summarily, the court can even order that there should be trial, so that the Garnishee may probably become, depending upon either how it is, either we treat as a plaintiff or the defendant for purposes of that trial, as it were. Because the court wants to know what the truth is, whether the money is freely standing, with the Garnishee, or the judgment debtor has colluded with the Garnishee so that the money will not be made available, as it were. Rule 6. If in Garnishee proceedings, it is brought to the notice of the court that some person other than the judgment debtor or other the judgment debtor is or claims to be entitled to the debt sought to be attached or has or claims to have a charge or lien on it, the court may order that other person to attend before the court and state the nature of the claim, the particulars of it. After hearing any person who attends before the court in compliance with an order under sub-rule 1, the court may summarily determine the questions in issue between the claimants or make such other order as considered just, including an order that any person or issue necessary for determining the validity of the claim of the other person, as is mentioned in sub-rule 1, be tried in any manner in which any question or issue in action may be tried. So quite apart from the Garnishee, the third party having objection, the third party may also say that, well, yes, we have some monies who belongs with the judgment debtor. But then we are also aware that there's a fourth party who has some arrangements with the judgment debtor. which we are aware according to those arrangements, and for which reason, not until we are told that the judgment debtor has satisfied whatever obligation towards the fourth party, we cannot just make the money available to the judgment debtor. So once you say that, the court may order that so-called fourth party, as it were, to be brought into the proceedings, for him to also provide explanation. If the court does not satisfy somewhere, the court may order them to actually go into trial, so that everybody will bring evidence to probably convince the court, as it were.
But
yeah, Rule 7, the court shall not make an order under Rule 1 requiring the Garnishee to pay any sum or for the credit of the judgment creditor resident outside Ghana, unless the judgment creditor produces a certificate that the Bank of Ghana has given permission under the Exchange Control Act at 71 for payment unconditionally or conditions which have been complied with. Yeah, so that is why when we're looking at the 47 Rule 4, an exception was made. So if the Garnishee is resident outside Ghana, then we need the certificate of the Bank of Ghana to do what? To come in under the Exchange Control Act. Yes.
I want that Garnishee is going to be supposed to be against a particular count of the judgment debtor or against the bank, so that, like, no matter the account that the person has. I've asked this question on the back of something that happened in court, where the Garnishee bank came saying that the company, the judgment debtor was was account of Metropolitan Assembly.
Yeah.
But they came saying that the account that they have is not account Metropolitan Assembly, but AMD. So for which reason they will not. So that was the excuse that they had. So later, when I think the judge said something, they came back. So the judgment creditors, I think, amended something. I don't know what it is. But then the judgment, the Garnishee bank came back saying that no, the AMA they had is A.M.C. So, like there was a lot of back and forth. So, I want to know whether the Garnishee is against the bank or a particular account so that they can get out.
Good. Yeah, I mean, it's a very important question, which she has asked. Good. And that is why Order 46 is important. The examination of the judgment debtor. If the judgment debtor is the one who knows where he has accounts, which accounts, isn't it? Yeah. And because he or she is put under oath, you get information. So that when you are going to do your Garnishee NICE ex parte application, of course, it works both ways. If he provides information, every judgment debtor knows that his monies can be subject of a Garnishee proceeding. So they will act fast to empty the account. It happens all the time, unfortunately. See, it happens all the time. Yeah, so if the Garnishee is made, depending upon the information you put before the court, if you put specific account before the court, that is how the court will make the order. If we just put the name and then certain other identifiers, maybe the name, and unfortunately now we have the bank. I mean, the Ghana card number is a very good thing because now they've linked the Ghana card to the account, isn't it? And one person, one Ghana card number. So if you say Kwaku Mensah or Eku Etonam, you have only one Eku Etonam with that Ghana number. So that will make it easier now. I'm sure that that problem may become a thing of the past. So now it is prudent when you are making your request for Garnishee nicely. Not just to provide the name of the judgment debtor, but then to provide the proper Ghana card as well, isn't it? Yes. So that you have the information there. And even as part of your strategy, as part of the case, when you are doing the trial, find a way to tell the person that the person is not a registered Ghanaian. You say, I'm registered. Produce your Ghana card at the time. So yeah, they'll pick the information so that if it becomes necessary at the execution stage, you are already armed. Yeah, so that is how it is. Otherwise, if it just echo etonam, the bank will come and say they will have a sales of them. So we are sorry, we don't know which of them we are talking about, but we are here. We have a sales echo etonam. But then if you added an identifier, then that one to solve this problem, isn't it? Yeah, so just before we go, this chart of Garnishee or judgment debtor order 47/8. Any payment made by a Garnishee in compliance with another absolute under this order, and any execution levied against the Garnishee under the order shall be a valid discharge of the liability of the Garnishee to the judgment debtor, the extent of the amount paid or levied, notwithstanding that the Garnishee proceedings are subsequently set aside, or the judgment order from which their rules are reversed. So, what order 47/8 is telling us is that now we have this third party, that's the Garnishee, let's say a bank. The judgment debtor, Kofi, has money with the bank. Okay, so let's use my rural bank. I'm a significant shareholder of the rural bank here. So because of the Garnishee proceedings, the court has ordered the rural bank to pay 500,000 cedis, which the judgment creditor owes under judgment to the judgment creditor. So let's suppose that all the money Kofi has to the rural bank is 550,000 cedis. Now, because the Garnishee, 500,000 has already been paid. So order 47/8 is saying that the money which the rural bank has been ordered by the bank to pay, by the court to pay, under Garnishee, will be considered as a lawful discharge of any obligation it has towards the account holder. So Kofi is the account holder, and the bank has obligation towards Kofi with respect to the money, isn't it? But order 47/8 is saying that because the bank paid the money pursuant to the Garnishee order made by the court, whatever obligation that the bank has in law towards the account holder are considered as having come to an end with respect to the amount. So with respect to the 500,000, the Kofi cannot sue the bank if the Kofi makes a demand, as it were. It doesn't matter that the judgment under which the Garnishee was made is later on reversed on appeal. It doesn't matter. Or even if the Garnishee is even set aside later on, it doesn't matter. Now, any payment made by a Garnishee in compliance with another absolute under this order, and any execution levied against the Garnishee in pursuance of the order shall also be a valid discharge of the liability of the judgment debtor to the judgment creditor to the extent of the amount paid or levied, notwithstanding that the Garnishee proceedings subsequently set aside, or the judgment or the order from which their rules are reversed. Yeah, so that is it. Whatever money the judgment debtor is supposed to pay, once the Garnishee has paid, is considered as a goodwill payment, as it will, regardless of what happens later on. Now, finally, Rule 9, where money stands to the credit of a judgment debtor in court, the judgment creditor is not entitled to take Garnishee proceedings in respect of that money, but may apply to court for an order that the money or so much of it as is sufficient to satisfy the judgment or the order sought to be enforced, and cost of the application to be paid to the judgment creditor. Yeah, so you can go to court and ask the court that, yes, the money which is being held, part of it should be paid into court for satisfying any judgment which may actually be given. Unless the court otherwise directs, notice of the application shall be served on the judgment debtor at least 7 days before the day named in it for hearing the application. And the money to which the application relates shall not be paid out of court until after determination of the application. And the court which hears the application may make any order with respect to the money in court as it considers just. So cost may be awarded. The cost of the proceedings will actually be paid as part of the judgment debt, as it were. Yeah, so we will continue with the execution. We'll look at the two more things, and we'll discuss interpleader at our next meeting. And we also discuss appeal, and then we'll discuss under 66, administration of estates. Now, I think that we'll be finishing the course. Yes. The mock is 2 weeks time, isn't it? And then we have one more class, isn't it? Yes, so, sorry. We do revision every day that we meet. Today we've done revision on joinder, isn't it? So maybe after the mock, we have a lot of free time, and we'll be doing a lot of, because after the mock, I'm sure you have developed there by one topic or we finish the course. Then the rest will go over everything. You'll be doing a lot of question and answers. We're doing drafting. So at least we have about 1 month to do that before you do your exam, isn't it? Yes. Yes. Yes.
One thing prepare ourselves for the morning get of the drafting later is
Oh, okay.
so that after the fall, then we do the subtracting one kind of
now, because you don't have certainty of whether there'll be no questions, so I would prefer that next week when we come, you hold yourself and allow me to teach continuously for about 2.5 hours. And I will use 20 minutes to do some of the drafting. If we agree, that should be fine. Do you agree? All right, thank you. All right, thank you. Lady, okay, thank you.